Your Worship, thank you for mentioning. Your Worship, one.
आपके कोर्ट मास्टर ने आपको इवेंचुअली रिजेक्ट कर दिया।
Your Worship, for withdrawal, Colonel.
उसके लिए क्या करेंगे? Court master has all the authority to. He has been instructed to allow all the mentioning, and if he wants to reject it, he has to take my consent. Okay, that is the norm of the court. For listing, it's your right. Case take up होगा कि नहीं होगा, इसका हम कोई गारंटी नहीं दे सकते, लेकिन लिस्ट होगा और हर केस में डेट पड़ेगा. There will be no case once listed without date. Okay, got it?
From supplementary list for orders for the result case of item 1, first appeal 59 of 2025.
You wish to withdraw this case?
Your Ladyship, idea has been filed for withdrawal of the appeal.
FA number 1942 of 2025 with IA number 2817 of 25. Interlocutory application has been filed seeking withdrawal of the first appeal unconditionally and without any resolution. Considering the interlocutory application, this first appeal is dismissed as withdrawn. Prayer में जो भी चीज़ है सब कोट कर देंगे. Any particular reason why to withdrawing the first appeal?
The parties are agreeable that it has to be.
That's fine. Sign the documents. आप नाम बताएं अपना.
Saurabh Raj.
सौरभ
Raj.
Raj. Under instructions of advocate on record.
Yes, India.
कौन है advocate on record?
Shashank Shekhar.
शशांक शेखर appears in this case.
Orders may defect item 2, first appeal filing number 10637 of 2024.
Yes, please. You have defects. How much time do you need to remove the defects?
We look at time for 2 weeks.
That should be sufficient. Have you seen the defects?
Sorry? 4 and 69 are arising out of same thing. Only 40 and 47 need to be looked at. So,
FA number filing number FA 10637 of 24. Counsel for the appellant. Your name?
Achal Singh.
Sorry.
Achal Singh.
Give your name.
Appearance.
Praise for and is granted. Time till 11th of April to remove the surviving defects preemptively. If the defects are removed within time, pose this case on 16th of April under appropriate time.
From daily list for final disclosure item 1, first appeal 1 of 2022.
Yes, appellant. Take your time. पहला केस में भी आपने
Mr. Nina is on in code number 1. It's my
We will see. देखिए ऐसा है कि सबका टाइमलाइन फिक्स्ड रहता है.
If
नहीं होगा तो कोई भी केस अब हम सोचे आज पास ओवर होगा कुछ होगा डे टू डे लिस्ट करेंगे और जिस दिन मन होगा उस दिन आप डिसमिस फॉर डिफॉल्ट कर देंगे. Because we do not know कोई भी केस टेकअप होगा वो 3-4 घंटे टेकअप होगा. Possible मेरे स्पीड के अनुसार as per my capacity, right? I take time to understand.
इसमें थोड़ा शुरू हम कर देते हैं फैक्ट बता देते हैं. In the meantime, I think he will be coming Lordship, because I have also a difficulty Lordship. Serial number 4 Lordship it will be taken after one case. लगातार 2 केस तैयार होना हम लोग के लिए difficult.
वो यही बात है.
तब हम इस पर भी आज तैयार हैं.
Quite some time.
तो
नहीं हो सकता.
मैं start things. I think he will become.
ये फर्स्ट अपील है. प्लेन written statement आप भी चालू कर सकते हैं. We'll start off with that.
I think he will be coming in 5 minutes.
My Lord, the judgment is at page 31. May I place the entire
Saurabh,
judgment?
I don't need you now. You can leave. और जिसका भी next slot है उनको भेज दो जब उनका टाइम होता yes
May I place the entire judgment? Page 31.
not the judgment we will not start with the judgment we will
Yeah.
start with the plaint
My Lord.
first appeal में हम लोग judgment से शुरू नहीं करते हैं और you say that in the judgment the facts are correctly mentioned नहीं
Yes,
लेकिन
yes.
plaint से ही ज़्यादा ठीक
एक हुजूर एक just before he starts, we have filed the plaint for partition of the one building lordship, which was allotted by the cooperative society in Bhopal. That was lordship leased in the name of the father of the plaintiff and the defendants. For that lordship, we have filed a partition suit, declaring our 1/5 share in that suit property. It has a 2-storied building. It is a 2-storied building and some outhouses also there. And some rents are also being collected. It was collected only by defendant number 1, who is the appellant herein. And the entire property was also in his possession. And being the brother and sisters, defendant number 4 to 5 are 2 to 5 are the 2 to 4 are the sisters. Defendant number 5 lordship happens to be the cooperative society of Bhopal. They have supported the claim of the plaintiffs, but defendant number 1, but none of the defendants, 2 to 4, my sisters, they have also supported my case. Now, one glaring thing is there in this case, that they have avoided so many things in the written statement, but neither they have deposed anything, nor they have filed any chit of paper. No exhibits are there on the document. Considering all these things, lordship, my plaint was allowed. This is the background of the case. Now they can start.
since you have given the background I want to know property was allotted in whose name
In the father of the plaintiff and defendants.
father expired
Father expired.
father expired so
The
it
mother
is
was nominated in the
as a nominee
as a nominee
She
in the
received
cooperative
the
society. Yes, lordship. Mother also expired. They had a claim that thereafter mother nominated defendant number 1, and mother also executed a will in favor of defendant number 1.
probated
That is there. That I'm coming to that. Lordship. Neither they have produced the will. They have gone for probate. The person who was the executor, he had gone for probate. That probate was rejected. We have annexed the judgment of the probate, saying that the mother had no authority to will the property of the entire property, which has devolved upon all the legal heirs of the.
certain she was not the sole surviving
So, and therefore it was rejected. Now the probate goes, will goes, everything goes, and the nomination which was done by the mother in favor of the
Mother
defendant
also
number 1,
expired.
mother also expired. In favor of defendant number 1, by the cooperative society, which the cooperative society is now supporting the case of the defendant number 1. But once it was appealed before the registrar and the revision was also there, both the registrar and the revisional court have stated that no, the mother could not have nominated.
Nominee is
Yes,
only for
yes.
the purposes of
Even
one
for-
person to
yes, yes. Even for
it
that
does not
purpose.
decide succession
Even for that purpose, what the courts have held, that since there was an objection by the plaintiff, and therefore without deciding those objections, these kind of nomination cannot be sustained in the eye of law, and both things have also been exhibited by us, both the documents. Now, nothing remains in this case. I have
ऐसा नहीं देखिए भाई अब मिस्टर पांडे नीरज
Yes,
भाई
yes.
अभी अपीयर होंगे
yes.
आप देखिएगा वो
This is
कहाँ
the
कहाँ से क्या क्या पॉइंट निकालेंगे ऐसा नहीं ऐसा हम सुन लिया आपकी बात लेकिन ऐसे देखिए इनकी बातों से मैं प्रेजुडिस नहीं हुई ठीक है आप अपनी हिसाब से अपना
Only the
केस
background,
करिए
I never wanted only the background. I have
That's
given,
right.
Yes.
ओके
I am reading plaint from paragraph that the plaintiff and defendants are biological Hindu covered by Mitaksari school of Hindu law and they jointly inherited the right title, interest and possession in and over the suit property described in Schedule B below from their father late Ram Naresh Tripathi.
no dispute so far as this is concerned
That late Ram Naresh Tripathi was an employee of the Steel Authority of India Limited, Bokaro Steel Plant, and was also a member of Bokaro Steel Employees Cooperative House Construction Society Limited, which is a society of employees of Bokaro Steel Limited, now say registered under
no dispute
no. Now registered under Cooperative Societies Act 1935 and is a body corporate having power to acquire and hold property to enter
no
into
dispute
no. to institute and defend suits etc in its own name, that the said cooperative society which has been made a party to the suit as pro forma defendant being defendant number 5 was granted lease of approximately 90 acres of land by Bokaro Steel Limited.
No dispute.
No.
Next.
And the society accordingly developed the residential colony as per layout plan at Bokaro Steel City, which is known as cooperative colony. That late Ram Naresh Tripathi, by virtue of being a member of the said society, by membership number 31
No,
was
that's right. Since this background of Bokaro Cooperative Society
this
is well known to
regard
everybody.
Membership of my father
Yes,
in
yes.
the society.
No problem. Para 5.
Fine. That after coming in possession of the said land, late Ram Naresh Tripathi constructed a double stories
No problem on this.
building consisting of 2 flats on each story. Out of 2 flats on each of the story, one of the flats consists of 4 room. One of the flats consists of 4 room, 1 kitchen and 2 latrine bathroom, stretching
right.
over an area of approximately
No dispute on
150
this.
square feet. And the other flat it should be flat. And the other
That's
flat consists of 2 room and
No
so and so
problem. You
on.
don't need to do
That besides the main building referred to, there is one outhouse consisting of 2 units. One unit
No
consists
problem
of
with
2
this. Next.
That there is one garage.
No
in
problem
the-
with this. Next.
That 4 rooms unit on the ground floor is stretching
No
over
issues.
that the rent from the tenant is realized by Sri Balkesh Tripathi, who is the appellate head.
Yes.
And he is alone utilizing the same for personal benefit without giving any share in it to the plaintiff and other co-sharers dependents to which they are entitled.
This Bal Krishna Tripathi,
Is the appellate dependent.
B.K. Tripathi,
Let defend number 1.
is appellant defendant number 1. Okay. Carry on, please.
And he is alone utilizing the same for personal benefit without giving any share in it to the plaintiff and other co-sharer defendants to which they are entitled. The fact being so, it is necessary that a receiver should be appointed by the court to take account of the rent realized by defendant number 1 and to receive the present and future rent from tenants and manage the property properly to maximum benefit of all the co-sharers. That late Ram Naresh Tripathi died on 26 June 2004 with leaving behind him his widow namely Saraswati Tripathi and all the parties to the suit who have jointly inherited and succeeded over the same as lawful owner.
No dispute.
That late Ram Naresh Tripathi had nominated his wife as a person to whom his share of the society would be transferred after his death. So when Ram Naresh Tripathi died, his share in the capital of the society was transferred to his wife and she was substituted as a member of the society in place of her deceased husband. That Saraswati Tripathi also died on 27 February 2008, leaving behind the plaintiff and defendants as her legal heirs and successors who thereafter have jointly inherited and succeeded to the suit property.
So all these entire facts are not in dispute.
Well, some part of the written statements are required. to
Let
be
us see.
read.
Let us see. Read it simultaneously. Defendant number 1. Okay.
Reply, para-wise reply starts from para 8 of the WS.
Yes. Not wholly correct. Read it, please.
That statement made in paragraph 1 of the plaint are not wholly correct. Ram Naresh Tripathi since deceased and his descendants were members of the school of Mitaksara co-personally joint family. But after the death and at the time of death, Ram Naresh Tripathi, they were governed under the provision of Hindu Succession Act, and the suit property is a leasehold property of a society, and deceased Ram Naresh Tripathi as a sub-lessee with some definite matter of its right of survivorship had been guided by the norms between society and the sub-lessee with a subjective process of determination of nomination as per desire of the sub-lessee. Hence, thereof any relief of the said type of property may not be apportioned by way of partition by leaving aside the matter of nomination of the sub-lessee of the said leasehold property being acquired by Saraswati Tripathi, where plaintiffs Krishna Tripathi and answering defendant Balkesh Tripathi jointly and severally declared and relinquished their right title of scheduled suit property and the transfer of same in favor of Saraswati Tripathi have affirmed by the society and acquired her absolute ownership on the said property.
ये क्या है? Nomination of the sublease of the same leasehold
Sub-lessee.
property.
Ram
Sub-lessee.
Naresh Tripathi nominated her, his wife.
Okay, acquired by Saraswati Tripathi,
Ma'am.
where the plaintiff Shri Krishna Tripathi and
Answering-
answering defendant Bal Krishna Tripathi
Declared
jointly and
relinquished
severally declared and relinquished their right.
right.
ये कोई डॉक्यूमेंट लगाए हैं आप इसका? About relinquishment of right.
That was to be seen.
Okay. It's very important. You say that they have relinquished their right in favor of their mother. Okay, so I would like to see what is the evidence, and if there is any relinquishment, it has to be supported by some document. It cannot be just oral relinquishment.
That nomination authority has to be signaled.
All right. Yes, continue, please. Para 2 to 4 का reply करते हैं.
That the statements made in paragraph 2 to 4 of the plaintiff are substantially correct and matters of document and answering defendant does not admit anything which are beyond the record and beyond the right terms and conditions of the lease or premises of the subsequent period, specified period. Statements made in paragraphs 5 to 7 of the plaintiff are substantially correct. Plaintiff with an ulterior motive has suppressed the true import of the leasehold property and its consequence through the nomination specified in the deed of sublease. There is no relief or relief for parties and is sustainable. The allegations made in paragraph 8 of the plaintiff are not wholly correct. Besides, the answering defendant as well as none of the parties to the suit was in occupation of any portion of the property in suit. The plaintiff with an ulterior motive has made a deliberate false statement in order to lay a false claim over the property and no relief for partition of the property is maintained. The suit shall be dismissed. The answering defendant submits that the outhouses were
No, I couldn't get this. What does this mean? Para number 11. The allegations are not wholly correct.
yeah.
Besides the answering defendant, as well as none of the parties to the suit.
Was in occupation of any portion of the property in suit. Was be that means the mother was.
I don't know, because mother is not a party.
No, mother died.
Therefore, mother. So you want to
The
say
death of mother, the mother had nominated me.
that's right. The answering defendant as well as none of the parties to the suit. इसका क्या मतलब? मतलब nobody was in possession.
Except the mother.
कहाँ लिखा है?
It's not written here.
तो हम तो वही पढ़ेंगे ना जो हमको दिख रहा है.
Yes, yes. So none of the parties to the suit were in possession. It is narrating about a point of time when none of the parties to the suit were in possession.
आगे पढ़िए.
The plaintiff with an ulterior motive has made a deliberate false statement in order to lay a false claim over the property and no relief of partition of the property is maintained. The suit shall be dismissed. The answering defendant submits that the outhouses were of kacha structures with country type roofs and this defendant replaced kacha structure by pakka structure and also connected with the main building. Outhouses installed water pump and renovated the main building as well as with the fund of the answering defendant as he has been nominated by a process of rules of the society. After the sad demise of the father, the mother of the parties let out portions of the premises to tenants on his behalf. This defendant used to realize rent which never exceeded rupees 8,000 to 9,000 per month in total, contrary to what the allegations made in paragraph are maliciously false. With respect to the arguments made in paragraph 9 of the claim, this answering defendant admits that previously the rent used to be collected by the deceased mother of the parties who used to avail the realized amount of rent according to her will. And after the sad demise of the mother,
Just one query. The property was allotted in the name of the father. He nominated his wife. According to you, it's to transfer in favor of the wife after due nomination, and there was no objection from all the other defendants.
they, in fact, others agreed to this.
Others agreed to it. Others include you also as a defendant. Then thereafter, she nominated you.
Yes, that's what is going to come after this.
Thereafter, she nominated you, and this nomination was also with the consent of all the defendants.
That nomination, there's no record to that extent.
So-
that nomination
so-
is being accepted by.
So at the stage when father is nominating his wife, your mother, he takes the consent of all the defendants as per your case.
I'm getting it.
When the mother is nominating,
I'm getting it. You read.
she is not
What
taking
offered
the
to me.
consent of all the defendants.
Let me just check the edition. Offered to me. May I just also point out one thing which was trying to
Cooperative
point.
Societies Act, section 48. Mastery है मेरी cooperative society. You know that? चलिए, पढ़िए.
With respect to the arguments made in paragraph 9 of the plaintiff, this answering defendant submits that previously the rent used to be collected by the deceased mother of the party who used to avail the realized amount of rent according to her will. And after the sad demise of the mother, the answering defendant has acquired the right over the leasehold property and recognized by lesser cooperative society as lessee. In the similar process of law, Date Saraswati Tripathi has been recognized as lessee and such interest has been transferred to the answering defendant. So I was slow in coming to all this because whole night, I kept on searching for few things which I did not get. I must say.
Very clear.
And I'm still searching. And upon the disclosure of the said transfer of interest over the leasehold property before the lesser cooperative society, the answering defendant has been absolutely recognized as lessee and paying the charges to the lesser and realizing the rent from the injuncted tenant with the leasehold premises. Ramnesh Tripathi during his lifetime having declared by way of family arrangement of himself acquired, where he expressed his specific intention about the enjoyment of the suit property, that is leasehold property, in favor of his wife Saraswati Tripathi as a lessee, and hold the property with absolute right, and after a sad demise, this answering defendant would alone be entitled to the suit property. It was further declared that Ilashi may just allow the cost of the
Yes.
Besides the aforesaid declaration, Ramnesh Tripathi, according to the terms and conditions of indenture of service, has nominated their mother, Saraswati Tripathi, in respect of not only the share in Bokaro Steel. Sorry, leadership, I missed one paragraph. I skipped one paragraph.
It was further
It
declared.
was further declared that the father of the parties purchased properties out of his own fund at Ghaziabad in Uttar Pradesh and placed the plaintiff for use and occupation of the said costly luxurious household property. Such declaration was made by Ramnesh Tripathi since deceased in the document dated 4/10/2003 under the heading family arrangement. The said legally acceptable arrangement has been acknowledged by the plaintiff with his full satisfaction by the process of allotments of share of property. So and so Ghaziabad acquired the absolute right, title and possession of the same by the plaintiff. Besides the aforesaid declaration, Ramnesh Tripathi, according to the terms and conditions of indenture of sublease, has nominated their mother Saraswati Tripathi in respect of not only the share in the Bokaro Steel Employees Cooperative House Construction Society Limited, in respect of the property in suit as well as on 48/1990, in presence of the two witnesses and that too to the knowledge of the parties to the suit. And accordingly, after the death of father of the parties, their mother Saraswati Tripathi, since deceased, became the sole absolute owner of the building property within the suit land. The plaintiff as well as defendant, as they were aware of about the genuine existence of nomination as per terms and conditions of lease made by their deceased father in respect to the property in suit in favor of Saraswati Tripathi, they jointly submitted a declaration before the defendant number 5. The said declaration has been authenticated before the notary public. R.N. Ghoshal notary public, contrary to that averment, that after said demise of Ramnesh Tripathi on 28/6/2004, Saraswati Tripathi and the parties to the suit as well jointly inherited the property in suit is totally unfounded in motivation and untrue. While Saraswati Tripathi, the mother of the parties, was in absolute ownership and was in peaceful possession of the property of the suit, she had declared and nominated before defendant number 5 on 9/2/2008, by which the mother of the parties not only nominated this answering defendant in respect to the membership and share of the society, but in respect to the suit property as well. Accordingly, this defendant has been accepted as the owner of the property in suit and the member of the society by the defendant number 5. That besides the
So this nomination by the mother and notary public and with the consent of all the parties has been executed.
no evidence has been made. Defendants has not adduced any evidence.
तो क्या है ये सब चीज का क्या ही मतलब? When you are talking about a document and you don't produce it, कुछ है नहीं आपके पास.
इसलिए पता हम करेंगे
हाँ, कुछ नहीं करना है.
सब तो यही आ रहा है.
वहाँ होता है nomination. Cooperative society में there is a process of
That's
nomination.
what was the
And in
best
case of
argument.
dispute, you have to raise the dispute before the registrar, and registrar has got the right to decide it. This is subject, that decision itself is subject to a civil suit.
And that has been decided also.
Against them.
फिर क्या? कुछ बचा नहीं है. कोई बात नहीं. अब आप
प्रॉब्लम इस आगे है बिल.
will be probably
एक दिन और लेंगे.
एक दिन और
हाँ, अभी हम उसमें मेहनत कर रहे हैं. Because there was a peculiar situation, keeping aside all this. During COVID, when we could not attend court, the learned court allowed the other side to adduce evidence, took all the evidences on record, exhibited them. I got no opportunity. I had a right to further cross-examine. No evidence has been allowed. Nothing was afforded, and that was the day on which order had come for his transfer. Presiding officer, he passed the judgment.
This is just
Let me make myself more
देखिए,
responsible.
जो चीज
ये
आपका
हमारा ग्राउंड्स पे लिया हुआ है. It's not that But let me be very, very responsible when I am making such submissions. So please give me one more small opportunity. I know where I stand as of now. I have placed everything on record. Therefore, there is still a line of life left. If I was entitled to cross-examination and if that right is supposed to be afforded to me, I will be able to adduce those materials which have not been adduced. It's correct that my client has missed out on the best occasion, but the opportunity may still come to me because of this contrivance which was adopted by the other side. It is a case of no evidence from our side and wrongly admitted evidence on part of plaintiff's side. I will confine to that only. The associate counsel was keen to point out
आपका
that there was a
लास्ट
bill.
डेट कोविड-19 शुरू हुआ है मार्च 2020.
15 मार्च 2020 से माना जाता है डीम 20th से हुआ था लेकिन 15 से
नहीं
माना
भैया
जाता है
जुडिशियल ऑर्डर्स है
हाँ 15 मार्च से
not 15 मार्च से
Leadership
21st March the
21st
first lockdown.
Lordship is correct. 21st.
बट लिमिटेशन 15 मार्च से कैलकुलेट
हाँ।
अलाउ करते हैं जुडिशियल ऑर्डर से
7/2/2020 को आपका एविडेंस बंद हो गया prior to commencement of COVID-19 situation. उसके पहले भी आपको मौका दिया गया है टू रीड एविडेंस.
मेरा एविडेंस बंद हो गया करेक्ट उसके बाद
तो
उनका
आपका ये कोविड-19 का क्या कहानी?
उसके बाद इनका एविडेंस आया है मेरे
कब
एविडेंस
आया?
बंद होने के बाद
कब आया इनका? एडिशनल एविडेंस के लिए इन्होंने प्ली दिया था.
यहाँ इन्होंने लाया डॉक्यूमेंट्स इसको एडमिट कर लिया है 24 मई 2021 ऑर्डर शीट लगाया है
And all are public documents.
right it could have been in a normal course it should have been and even if a public document has been filed my right of cross examination doesn't go away
No such application is also there.
हाँ तो हमको सर्विस ही नहीं की है ना because the best part is कोविड के पीरियड में फाइल किए without serving to me I had no knowledge about
और कोविड-19 का पीरियड कब से कब तक?
कोविड-19 का पीरियड है फरवरी 2022 तक
Which will
28 फरवरी 2022 तक
off and on the courts was becoming physical. Thereafter again
कॉपी तो सर्व
online.
करिएगा कुछ भी करें How could court pass an order without serving a copy upon accepting something in evidence?
Parties
I am happy your ladyship that they have accepted this evidence. I am saying please accept it. That in fact gives me an opportunity to lay my evidence also.
Without any application.
you appeared through VC on 16/7/21 and you prayed for time to file written submissions.
That's a
You
different
prayed
thing.
for time to argue.
That's a different thing. But ये evidence जो court ने accept कर लिया, order has been passed on 20th of May, 24th of May. This should not have been done behind my back. If I have a case
would have been passed for recalling for cross
If I am
Did
able
you
to
take
convince
any
this-
steps to recall this order or to
Yes.
challenge this order?
Even for filing an application that I want to cross-examine my plaintiff.
This
No
order
such
is dated
applications.
24/5/21. Did you file any petition to recall this order or to
Cross-examine.
cross-examine or to do anything in connection with this
After
order?
24th of May, the order sheet is there. Doesn't
Yes.
seem that I have
16/7.
any other.
16/7, you say that you pray for time for argument. Both parties are directed to
मुझे
make
पता ही नहीं था
arguments.
कि ऐसा कुछ फाइल हुआ है, ऐसा कुछ हो गया है।
आपने written argument file किया था?
आप एविडेंस के बारे में पूछ रहे
नहीं, हम जानना चाहते हैं आपने written argument file किया था कि नहीं किया था?
हो। नहीं all these while the physical court was not functioning, so देखा जाएगा सब डीसी से अपीयर किया है।
It's a
Something is amiss, your leadership here. 16/7/2021, I am saying I want to argue. I am not aware that such an order has been passed. There was no access to us to these
Have you
orders.
said so? In your memo of appeal.
Round number H onwards.
H onwards नहीं है, एक ही ground काफी होता है. Single ground is more than sufficient. उसके लिए ground number H onwards बोलने की जरूरत है.
Someone had said honeycomb to na dosha. GH, GHI. Sir, page. This has been noted, your leadership, in order dated 10/3/2021 कि प्राप्त नहीं कराया गया है. 10/3/2021 order says वादी के द्वारा पिटीशन को एडमिट और मार्क एग्जिबिट द पब्लिक डॉक्यूमेंट फाइल्ड ऑन बिहाफ ऑफ द प्लेटिव एंड प्रेजेंट टू टाइटल सशक्त दाखिल की गई, इसकी प्रति प्रतिवादी या प्रतिवादी के अधिवक्ता को प्राप्त नहीं कराया गया.
आगे.
Parties take no step. Plaintiff is directed to serve the copy of petition.
आगे.
Plaintiff takes no step.
आगे.
COVID-19 के लॉकडाउन के कारण
नहीं आगे पूरा पढ़िए. Order dated 12/4/21.
Plaintiff takes no step on behalf of plaintiff and defendant number 5 are directed to come ready for argument. Put upon so and so for argument. COVID-19 लॉकडाउन के कारण पैरवी नहीं की गई. आज दिनांक इतना वास्ते बस 24/5/21 parties take no step and he passes the order. Then next, she was right. The next order 16/7/21 parties take no step. Lawyer for the plaintiff appeared through VC and already paid for time for argument. ये सब इनके बारे में parties take no step. Suit is called out. On call, learned lawyer of the plaintiff appeared through VC. Heard argument on behalf of the plaintiff. Defendants are directed to make argument. Put upon so and so for argument of defendant. Both parties take no step. Suit called out. On call, learned lawyer of plaintiff appeared through VC. Defendants are absent and take no step. Defendants are directed to make argument.
एक बात बताइए.
वादी
24/5/21 कोविड-19 के लॉकडाउन के कारण पैरवी नहीं की गई. बाद 16/7/21 बहस वास्ते. करेक्ट. और उसके बाद 24/5 को ही आपका एडिशनल एविडेंस का ऑर्डर हर्ड वर्चुअली थ्रू
Just
उसमें भी लिखा हुआ है कि parties are not appeared.
दिखाई. देखिए
मेरे पास है.
Have a look at this.
तो फाइल के
है ना?
कॉपी की. तो मेरा मूड पॉइंट
कॉन्ट्रडिक्टरी नहीं है.
कोविड-19 के लॉकडाउन के कारण पैरवी नहीं की गई है. वाद इतना को बहस वास्ते.
ठीक है.
Parties take no step to suspension of the physical court on COVID-19. The petition dated itna to admit the mark such and such on behalf of the plaintiff put up on virtual hearing. Heard virtually to just the meet app the land council of the plaintiff submitted such and such.
24/5 को ही
हाँ,
ऑर्डर.
the same date.
कैसे? How do you justify these two orders? And there is no recording that it has been served upon the defendant number, whatever the defendant. Because there is a specific recording that it has not been served. There is a direction to serve. No service report is there on record that you have served it. और आपका जो भी एडिशनल एविडेंस था या जो भी कुछ था, एक प्रॉपर वे है. They have an opportunity. They are bound to have an opportunity
Yes,
to
for that,
respond to that.
some application has to be filed. No application was filed.
No
That
application
is
was filed.
I have already
Your
stated.
leadership's question was,
Yeah.
we have made in paragraph 10 also a specific statement on affidavit. In paragraph 10, that on 10/3/21 the plaintiff filed an application to admit and mark exhibits the public document as without serving a copy of the same upon defendant number 1. Thereafter, without affording any opportunity to defendant number 1, the dates were fixed for hearing on the said application during pandemic COVID-19, while the court functioning was restricted and while the lockdown was running. The learned court below heard the petition dated 10/3/21 or 24/5/21 in the hostile situation in absence of the defendant and passed order of implementation allowing market.
तब कैसे होगा? इसको तो रिमाइंड ही करना
दूसरा
पड़ेगा
तो
क्या?
16 साल बाद में देखा है 17 साल दो डेट पड़ा है नो एप्लीकेशन
नहीं नहीं, आपका ये 24/5/2021 का 2 ऑर्डर को आप कैसे जस्टिफाई करेंगे?
इसको जस्टिफाई नहीं कर सकते।
तो आप जस्टिफाई नहीं कर सकते हैं,
इसको
कॉपी
justify
सर्विस कहीं रिकॉर्ड पर नहीं है। हाउ विल अ पर्सन नो ड्यूरिंग दिस कोविड-19 पीरियड कि वो पिटीशन फाइल हुआ है, अलाउ हो गया है? ये सब एक्सेस उसको कहाँ से होगा ड्यूरिंग कोविड-19? This kind of taking documents into record और ये 24/5/21 का order is absolutely contradictory to that.
both the orders are
Both the orders cannot be reconciled.
तो सर एक चीज और लगाए हम आइए करके
काफी
फाइल
नहीं है
करते हैं। तो एक चीज और इम्पोर्टेंट है वो ये 28/8/21 को जिस दिन जजमेंट प्रोनाउंस हुआ
देखिए उतना नहीं, उतना पे नहीं जाएंगे, उतना
नहीं ठीक है,
करना-
हम एक पॉइंट आउट करते हैं जो रिकॉर्ड में लाए पेज 10 ऑफ द सप्लीमेंट्री एफिडेविट दैट आई फाइल्ड ऑन 30th of January in which I enclosed the entire order sheet to demonstrate what the edition is already appreciated. 28 this judgment is ready to deliver, judgment delivered in the open court. And next page that was the day his transfer order.
तो क्या होगा?
Circumstances.
क्या circumstances? अब मेरा ट्रांसफर आ जाएगा तो हम जल्दी नहीं करेंगे। ये तो कोई मतलब नहीं है ना, you are refuting too much.
The way the court conducted itself
ऐसा नहीं है, ऐसा क्या सुन लिए, सब कुछ कर लिए, अब ठीक है जजमेंट बना के डिलीवर कर दिया। आप ये नहीं बोल
कहाँ सुने उसके पहले का
सुने,
पूरा उसको
सुने
बैकग्राउंड
है।
के साथ देखा जाए नहीं नहीं हर डेट में है कि हम नहीं ये लेडीशिप एक बार फिर से ऑर्डर शीट को देख लिया जाए लास्ट पेज जिस दिन जजमेंट प्रोनाउंस हुआ उस दिन का ऑर्डर शीट उस दिन का 4 ऑर्डर है बोथ पार्टीज टेक नो स्टेप नेक्स्ट वादी की तरफ से
एक
पेंडिंग नहीं
सेकंड,
की
एक
गई
सेकंड, एक सेकंड, एक सेकंड।
कब सुने
16 साल
कोई पक्ष उपस्थित नहीं 11/8/21 27/8/21 28/8/21
Attendance has been filed on behalf of defendant number 5. Judgment is ready. So this is the only day you had appeared?
उसके पहले हुई
वादी की तरफ से पैरवी नहीं की गई, प्रतिवादी की तरफ से वकालत
हम तो
हाजिरी की।
डिफेंडेंट नंबर 1 है उसमें
हाँ सही बात, पहले तो वादी बहस करेगा ना।
ये है 27/7 में आर्गुमेंट है
हाँ 27/7 को वादी की तरफ से बहस सुनी गई।
तो डिफेंडेंट्स का आर्गुमेंट दिया था नन ऑफ द डिफेंडेंट्स है
एक सेकंड, 27/7 को क्या है? 27 parties to takes 27/7 को लिखा हुआ है कि
Heard through
parties take no step.
since
Suit
lordship
called
COVID-19 lordship
Yes,
Hajri
yes.
and Tamas were not filed but they appeared through VC and the sorry not and the Hajri I'm sorry
Parties
Sorry.
take no
Okay,
step.
okay, okay.
पढ़िए ना 27, आपका कहना है 27/7 को सुनवाई।
हाँ, हाँ, सुनवाई हुई।
पढ़िए 27 तारीख का ऑर्डर पढ़िए।
parties take no step suit is called out on call learned lawyer of the plaintiff appeared through VC therefore since the Hajri was not filed in the court therefore it is recorded parties take no step
Heard argument on behalf of
Yes.
the plaintiff, defendants are directed to make
make
their argument.
arguments on 11/8/21
ये सब
Next
ऑर्डर
step.
शीट्स कुछ एक्सेसिबल नहीं था उस समय
वो था कि नहीं था, लेकिन और जब आप एक ही
जो
और
सर्कमस्टांसेस था उसको अप्रिशिएट कर लिया जाए आई कैन नॉट एवरीथिंग कांट बी इन ब्लैक एंड व्हाइट रिटन एंड आई कांट इंप्रूव अपॉन द डॉक्यूमेंट
you say that no the plaintiff also never argued the case. ऐसा तो नहीं, यहाँ पर 27/7 को सिर्फ प्लेंटिफ का आर्गुमेंट
जी
हुआ
उनके
है।
एडवोकेट खाली अपीयर किए वीसी से और
हाँ, उनके learned counsel for the plaintiff appeared through VC heard that.
हम लोगों को ये डायरेक्शन हो रहा है कि आप आर्ग्यू कीजिए कैसे पता चलेगा आई एम जस्ट पुटिंग अ क्वेश्चन टू माय सेल्फ उस समय जो सिचुएशन था हम लोग एक्सेस नहीं कर रहे थे वी वर आल्सो
VC से भी तो access नहीं कर
we were also appearing in so many courts those days we know what was the situation
defendants are absent take no
yes
steps
well I will
Defendant
not
directed to
advance
make
an absurd
argument
plea
on
आपने एक 27/8 को एक हाजिरी दी है
वो डिफेंड नंबर 5
और डिफेंड नंबर 5, यू आर डिफेंड नंबर 1।
Five is the
उस समय हम लोग काम ही नहीं कर पा रहे सिविल सूट्स तो हो ही नहीं रहा था एक्चुअली नहीं हो पा रहा था सिविल सूट्स
खाली डिफेंड नंबर 5 अपीयर हो गया।
cooperative society
हुजूर को तो वेयर विद ऑल है इससे ही रिपोर्ट मंगा ले जाएगी कितना सूट का डिस्पोजल हुआ इसके अलावा उस पीरियड में मान ले कि ठीक है इट वाज अ नॉर्मल
Now you tell us, on the face of this additional evidence and the contradictory order with respect to order dated 25/5/2021, there are 2 orders sheets on record. One shows that you have been heard, other shows that nobody has appeared.
Yes.
Right? And the fact remains that there is nothing on record that it was served on them. कुछ है नहीं, डायरेक्शन है, ऑर्डर शीट में कहीं नहीं है कि उनको सर्व किया गया है. रिकॉर्ड में भी अगर देख सकते हैं तो देख लीजिए, वो सर्विस रिपोर्ट होता है ना, यहाँ पे फाइल करते हैं ना,
नहीं कुछ नहीं है
वैसा कुछ
कोई
नहीं.
कुछ नहीं.
Therefore, this additional evidence is to be reconsidered, whatever it is.
Although it is a public document.
Maybe,
Yes.
even if it is a public document, they have got a right to cross-examine you. Maybe ask, maybe that ये जितने भी public documents ऐसे आते हैं, what is the procedure? Somebody will come and exhibit it, or ये automatic exhibited?
It can automatically be.
वो होता है एक
अगर मान लीजिए इनको मन करे आपको cross
हाँ,
examine
they can.
करने, they can.
But for that lordship, in spite of so many order sheets, not a single objection has been filed by
पता ही
them.
नहीं कैसा कुछ
And
काम
only ground they are taking that they are not doing it.
उनको सर्व ही नहीं हुआ ना, how would they know?
In spite of the order sheets,
ये
3-4
सर्विस
months have
सर्विस
passed.
नहीं है,
4 months have passed.
सर्विस नहीं है.
And these orders lordship are online. This is the type copy order lordship. These are online. Even at that time.
MCA ऑनलाइन होता
नहीं ये होता है.
उसमें ऑनलाइन उसमें ऑनलाइन तो बड़ी मुश्किल से हियरिंग हो रहा
These documents are online.
है ऑक्सीजन लेवल भी कम था.
The order sheet may not be accessible.
These orders are online.
This one lordship.
This order is online.
I'm supposed in many courts I've seen lordship the orders are online. When it is typed order dictated by the court, a reasoned order is there. That is all uploaded lordship. That is my submission.
Let's accept this that there was a petition filed without serving. I did not know that such a petition has been moved and allowed, and an order has been pronounced, and an order is online. I
देखिए
want to
आज 4 साल बाद कोविड के बाद जितना एसेसिबिलिटी
Yes, yes.
बढ़ गया है,
We have
उस
experienced
वक्त
lordship.
if you expect कि
No. We have
me or
experienced
you
lordship.
or he
On
would
that
have
point,
access to
lordship-
online platform
Yes, yes.
and then download the order from there, it is expecting too high.
और तब भी उसको कोई ओकेजन रहे तब ना उसको एक्सेस करने का. जैसे डेली ऑर्डर्स अगर आ रहा है, then I have a responsibility, it's a constructive notice that online orders are being published. You go and see.
उस वक्त सूट का हियरिंग नहीं हुआ.
उसका हियरिंग नहीं होता, इसलिए हम कह रहे हैं उसको एक रिपोर्ट मंगा लिया जाए for
नहीं हमको
satisfaction.
मालूम है ऐसा रिपोर्ट की कोई जरूरत नहीं है. सूट
we
का
are
hearing
Leadership,
order
I am being
नहीं
slow
हुआ.
in being very vocal about what I wish to say. The indications are sufficient. I have stated so. And record suggestions.
These are all
Record
hypothetical. Whatever he is thinking, it is all.
No, it's all on instructions.
instruction.
Instructions which I reasonably believe to be responsible.
अच्छा ठीक है, इनका तो फिलहाल इतना ही है, बाकी मेरिट में कुछ नहीं है क्योंकि इनके पास और कुछ है नहीं देने के लिए.
Even they cannot improve their case.
They
Even
cannot
lordship
improve
remarks
their
on that
case.
point. They cannot improve their
Only
case.
on the point of additional evidence only it will be remanded and then the case will be proceeded
Yes.
In accordance with law.
in accordance with law. उसके बाद ये क्या करेंगे नहीं करेंगे हम नहीं जानते. Additional evidence देने के बाद ये क्या हो सकता है, कोई evidence देना चाहे, हो सकता है open करना चाहे. We do not know what all he can do. Right?
Whatever is legally
Only to the
permissible,
point
judicial we will do.
lordship, it can be recalled. The trial court may be directed to give them opportunity to cross-examine the plaintiff because
No,
once they
that
have-
evidence can't be accepted. I will oppose and show that this evidence would not be taken into the cross-examination. तो बाद
That
में
is
इसको
what-
accept कर लेंगे.
that is what in cross-examination.
So
only you
leadership
can do.
is leave it at the stage where order dated 10th of March was passed saying that serve copy.
Then
And
under
after
such
that, whatever.
circumstances we have another option. वो ये कि ये जो आपका क्रॉस एग्जामिनेशन या पिटीशन की कॉपी करके उस पॉइंट पे हम बोलते हैं कि वो एविडेंस लेके यहाँ भेज दें.
Yes,
Maybe
that is what
decide
I'm
the first
saying.
ये तो उसके
Yes.
बाद हम तो क्रॉस एग्जामिनेशन करेंगे तो हम
आप सब कुछ करके आइए. On
On
the
that
point of
point,
additional
yes.
evidence, whatever it is, you do and come.
Yes.
जजमेंट होगा ना वहाँ से दोबारा
नहीं,
उस मटेरियल का
You see, there is a
Remand
process
is provisional
also.
remand.
after
On this
after
point-
additional evidence is adduced your leadership I get opportunity to produce my evidence also. It can't be that his evidence has come and I will not be able to rebut it. Not only cross examination.
That was already closed. No application for reopening those things have
Leadership,
come.
the best solution is that it is sent back. Let there be a time frame fixed for disposal of the suit. I don't know.
If there is any apprehension in the mind of the court lordship, then that can be removed.
There are other arguments, leadership. If
अच्छा आप एक बात
an additional
बताइए.
evidence
Just a
comes-
moment. Forget about the additional evidence. What evidence is there on record? Even if you forget the additional evidence, can the order?
ना, उनका भी नहीं है मेरा भी नहीं.
कोई भी आपका भी कोई डॉक्यूमेंट नहीं है, इनका भी कोई डॉक्यूमेंट नहीं है.
102 of the Evidence Act will come into play. They will fail if no parties have produced evidences. I will be very happy.
How that can be done? My evidences have been accepted by the court.
Wrongly, in violation of principle of natural
No,
justice.
these
That is cited in the
documents-
first appeal then.
These documents, whatever you have filed,
Yes.
you have not filed any other documents apart from this.
Those are the only documents, Lordship. For the lease deed, where my averment is there in the
You
plan.
see, those are admitted facts.
Yes.
Need not be proved.
No, it is not an admitted fact. They are saying their will is there. They have never averred about the probate. Subsequently, the probate judgment came.
You see,
They
will
have-
is a sheet of paper has got no consequence.
Which
As will is a
Yes,
simply
yes.
sheet of paper.
The nomination.
In absence of that, it has got no relevance.
Yes, Lordship. The nomination has subsequently been cancelled by the registrar and the appellate authority, revisional authority,
Nomination in whose
in
name?
favor of the defendant number 1 by the mother has already been cancelled. Those documents are required to be brought on record.
All
The
this
lease
is
deed,
in the
although
real-
we have averred in the plea that the entire lease deed, the original lease deed, is with the defendant number 1. They did not produce it. We obtained the certified copy of the lease deed and thereafter it was exhibited as Exhibit 1. These are the documents which are required to be seen.
In post-COVID present situation, we must be afforded to join in the litigation afresh at the stage of, from the stage of grievance, subsequent to the stage of grievance. Let them adduce whatever evidence they want to adduce, let me adduce whatever evidence I want to adduce, and let there be a fair adjudication.
I will simply say that your right to adduce evidence was closed on 7 to 2020. During that time, the COVID-19 situation was not there. Parties were physically
Situation
appearing.
had already come by that time.
Parties
but-
were already appearing before the court, even on that
Oh,
day.
yes.
Right?
This
Parties were
first patient
appearing.
we had in January.
No, first, you see, this order we are not going to satisfy. First. So, therefore, thereafter your grievances, there was additional evidence placed on record by the plaintiff, and you have not been given any opportunity. With
To
respect
oppose,
to
to oppose adduction
For
of evidence.
rebuttal.
the
To oppose the adduction of evidence. Rebuttal तो बाद में होगा.
with respect to the additional evidence. Correct? With respect to the additional, whatever be your opposition, there can be n number of
Judiciary will
opposition.
record this. I am making this submission.
I
To
will-
oppose adduction of this evidence.
Yes, certainly. To oppose, naturally you will
I
oppose,
did
you will
not
not
get
support it.
opportunity to-
Support ही करना होता तो यहाँ क्यों ही
नहीं,
लड़
कभी
रहे
कभी होता है आप हम उसको आने देते हैं. आने के बाद फिर प्रोसेस सबमिशन करते हैं.
We do not.
I might in this
With
case allow
respect,
this.
since this petition seeking additional evidence, copy was not served upon him as per the records.
Yes.
Therefore, he had not got the opportunity with respect to the additional evidence. Now, on the point of additional evidence which has been taken on record by the learned trial court, I will remit the matter only to that extent. Ask the trial court to do the needful with respect to the additional evidence. Whatever they have to do, let them do.
Within a certain period.
And then return the finding with respect to the additional evidence. And then we'll proceed and decide this.
Additional evidence
Yeah,
नहीं
yeah,
है
बस-
application
आपको
application
जो
for
करना है आपको।
application for evidence additional evidence बोला है. इसलिए कि हम additional evidence तो ट्रायल कोर्ट को ये न लगे कि impliedly court has
आपको
accepted.
तो एप्लीकेशन मिला ही नहीं.
नहीं मिला.
हाँ तो बस आपको एप्लीकेशन सर्व होगा, आपको जो जो ऑब्जेक्शन करना हो कर
ये-
दीजिएगा. इतना ही है.
बस इतना ही.
बस उतना पर. ये किस ऑर्डर में होता है ऑर्डर?
Lordship.
Additional evidence.
नहीं नहीं, ये जो ये लिमिटेड
Remand, yes.
हाँ.
41, 23A. 23 also. 23 onwards. 23 and 23. It will be 25 Lordship.
20. or to determine any question of fact.
Yes.
Sir, इसमें आ जाएगा additional
Yes.
evidence.
25.
Once your ladyship's order clocks us back to the date on which court passed an order, that copy will be served, everything will automatically follow.
Right?
Everything will.
देखिए.
That
Or
will be
25.
clarified, that the
I
court
will-
has
I will
not,
clarify.
court has not
I will
hindered.
clarify that the order sheet is not indicating that
Yes.
that
Order
it has been
25
served.
is sufficient.
And since you have a grievance that it has never been served, in the meantime the COVID-19 situation came and ultimately the final judgment was passed. So on account of non-service of that, you will get a copy. आपके पास copy है?
Yeah.
नहीं.
Provide कर देंगे.
Provide कर लेंगे.
To the concerned.
Record में कायदे से रिसीव करवाइएगा.
हाँ, बिल्कुल अब तो कराना ही पड़ेगा. So now we'll be more cautious. Once bitten, twice shy.
Copy you will appear through वकालतनामा. Fresh वकालतनामा आप देंगे. पुराना वकालतनामा में नहीं चले. You appear, you give him the copy immediately on the date of his
And date will
appearance.
fix
I'll fix a date from here for the service
Yes,
of that
yes.
petition also, along with the
For
enclosures,
appearance and service of copy.
documents, and then he will respond within how much time?
Oh, this. Please leave it on the trial court. Once the order has gone from here, they will act very cautiously.
2 months should be sufficient.
3
देखिए,
3 months कर दिया है बीच में.
3 months.
हाँ, इस बार.
First appeal number 1 of 2020. Heard the learned counsels appearing on behalf of the parties. During the course of hearing, the learned counsel for the appellant has submitted that the order sheet revealed that on 7/2/2020, the evidence of the defendants was closed. He submits that soon thereafter, COVID-19 situation
Got
Comments?
aggravated कर दिया है.
sorry,
Got aggravated कर दिया है. Commencement of
COVID-19 situation got aggravated, and after the closure of the evidence with respect to the defendant, the plaintiff had filed a petition seeking to adduce additional evidence by producing certain documents, which has been recorded in order dated 10/3/2021. And it has also been recorded that a copy of the same has not been served upon the defendants. There is another order dated 22/3/2021, wherein the parties did not take any steps, but plaintiff was directed to serve the copy of the petition dated 10/3/2021 to the defendants. The matter was directed to be posted on 12/4/2021. On 12/4/2021, the defendant number 5, who was the pro forma defendant, had appeared and parties were directed to come prepared. On 24/5/21, the learned counsel submits that there was specific order. There were specific orders asking the plaintiff to serve copy of the petition seeking to admit additional evidence. But there is no such recording in the order sheet that a copy was served. Rather, the petition seeking admission of additional evidence was never served upon the counsel for the defendant number one. एक ही था कि सब अलग अलग थे.
One is contesting.
Contesting defendant number one.
Yes.
Defendant number 2 is supporting.
Well,
Contesting defendant number one, and ultimately the order dated 25/5/2021 was passed, whereby the additional evidence was taken on record. He has submitted that on 24/5/2021, two orders of the same date has been drawn. One order revealed that on account of COVID-19 lockdown, no steps have been taken, and the next date fixed for hearing is 16/7/2021. And on the same date, that is 25/5/2021, another order has been drawn that the learned counsel for the appellant was heard virtually. The learned counsel for the appellant has submitted that on 25/5, on the order dated 25/5/21 itself, it has been recorded at the end that the defendants shall have liberty to rebut the same by submission and documentary evidence. But the said order dated 25/5/2021 having been passed in COVID-19 situation,
24/5.
24/5/21 having been passed in COVID-19 situation, and ultimately the matters were fixed for argument during COVID-19 situation on 16/7/21, 27/7/21, and on 27/7/21 the plaintiff appeared through VC and his arguments was heard.
Plaintiff's lawyer कर लिया, plaintiff did not take steps on it.
Sorry?
The order says plaintiff, no parties have taken any steps. So therefore appearance leadership is noted. Appearance is by the advocate. Order में आ गया plaintiff argument. Plaintiff's advocate arguments.
I believe. Yes. On 24/5/21.
The order sheet says plaintiff's lawyer appeared to argue. Surprise.
24/5.
24/5 तो हो गया.
हाँ, okay.
आगे उसके बाद appear किया.
Plaintiff's lawyer
Yes, plaintiff lawyer.
appeared through, why plaintiff will always appear through advocate. Appeared through VC to argue, and the defendants were directed to make their arguments. And ultimately, during COVID-19 situation itself, on 28/8/2021, the final judgment was delivered. The learned counsel has submitted that during the COVID-19 situation, the physical presence of the litigants as well as the advocates was highly restricted, and the matters were being taken up through VC mode.
And the order sheets were not accessible. That's my
Just a minute. Just a minute. And accordingly, the right of the defendants to rebut the same by submission and documentary evidence would not have been availed. This is over and above the fact that the orders drawn in the files were not accessible. And also the fact that order dated 20 and also the fact that on 25/5/21 two contradictory orders have been drawn.
24.
24/5/21 two contradictory orders have been drawn. One indicating no appearance and no steps taken by the parties, and the other indicating that the counsel for the plaintiff was virtually guilty. Admittedly, on 24/5/2021, the appellant, defendant number 1, was neither present through VC or otherwise.
Let's admit it.
The learned counsel has submitted that the defendant number 1 appellant has been highly prejudiced by the order dated 25/5/2021 by which the additional evidence has been taken on record without serving copy of the petition seeking to adduce additional evidence, and therefore the impugned judgment which has been passed by the learned trial court, which is primarily based on the additional evidence, uska submission, which is primarily based on the additional evidence, cannot be sustained in the eyes of law. The learned counsel appearing on behalf of the respondent plaintiff has submitted that the order dated 25/5/2021 is a detailed order, and the additional evidence which has been sought to be, which has been accepted, are primarily based on certified copies. Certified copies are primarily the certified copies which were marked as Exhibit 1, 2, 3 and 4. And the defendant was also given liberty to rebut the same by submissions and documentary evidence. But no steps was taken by the defendants,
Contesting.
by the contesting defendant number 1. However, during the course of argument, it is not in dispute that there are two orders drawn on 25/5/2021, one indicating 24/5/2021, one indicating that none of the parties have taken any step and the matter was adjourned to 16/7/2021 for argument, and another on the same day, 24/5/2021, showing that the plaintiff was heard virtually
On a petition dated 10/3/2021.
on petition dated 10/3/2021, seeking to adduce additional evidence, and the same was allowed on that date. During the course of hearing, it is further not in dispute from the side of the respondent plaintiff that a petition was filed seeking to adduce additional evidence, and the plaintiff was directed to serve a copy of the same to the defendants, but there is no recording in the order sheet
Yes.
that it has been served upon the defendants. And in the order dated 24/5/21, it has been recorded that though given opportunity, no rejoinder has been filed on behalf of the defendants, and none turned up to take part in the hearing on due intimation.
Yes. Further, Lordship, my another argument is that, in spite of all these, they never approached the court for filing an appropriate application either for recall or for cross-examining the plaintiff.
The Learned Counsel has further submitted that, in spite of all this, the defendant number 1 never approached the Learned Court for recall of order dated 25/5/2021 or to file any petition for cross-examination of the plaintiff with respect to the additional evidence, nor took any steps pursuant to order dated 25/5/2021, wherein the defendants were given liberty to rebut the additional evidence by submission and documentary evidence. However, the Learned Counsel for the respondent has, however, without prejudice to the aforesaid submissions, the Learned Counsel for the respondent has submitted that merely on account of the aforesaid facts and circumstances, the impugned judgment may not be set aside, and this court has ample power under Order 41, Rule 25 to ask the learned trial court to return a finding in connection with the petition seeking to adduce additional evidence, and after granting an opportunity to the defendants to, so that finding may come before this court and appropriate judgment be passed. The Learned Counsel has submitted that if the learned trial court ultimately finds that the additional evidence is admissible, then
Which is a
those
public
evidences have already been taken into consideration by passing the finding. यही है ना? What I am saying is that if ultimately the learned trial court finds that the additional evidence are to be taken on record, then those documents have already been taken care of by the learned trial court by passing the opinion. If one or the other additional evidence is rejected by the learned trial court, that aspect of the matter can certainly be taken care of by this court in the appellate jurisdiction.
Yes.
Once the findings are so returned. That's all. After hearing the learned counsel's appearing on behalf of the parties, this court finds that it is not in dispute that on
One thing is there, after the evidence is accepted, I may take steps to adduce my evidence also. To rebut
आपको
it.
तो मौका मिला ही है, आप देखे ही नहीं है.
उसके 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 बाद तो आपको पता ही नहीं था ना.
जब मौका, इसीलिए वो तो ऑलरेडी है, हम लिखे हैं इसलिए. देखिए आप बीच में कोर्ट छोड़ के चले जाते हैं.
नहीं हुजूर.
उसके बाद आप आके कुछ
नहीं,
बोलते हैं,
I-
आप
I-
हमारे
I-
डिक्टेशन में कुछ
I-
भी डिस्टर्ब
apologies.
आपको जाना ही नहीं था ना.
Apologies.
हाँ, इसीलिए रुक जाइए. After hearing the learned counsel appearing on behalf of the parties, आपको कुछ बोलना है? Other respondents? Sorry? Other respondents are not appearing. Cooperative, this Bokaro Steel, etc. They are not appearing.
But the present trial court cannot be made bound with the opinion expressed by the predecessor with respect to these evidences if the same has been accepted and
Both the things happen.
in our absence, and we are going to adduce our evidences also. It's to take
Mr.
everything
नीरज राय,
cumulatively.
आज के बाद से ना आप कभी कोर्ट छोड़ के मत जाएंगे. Please don't leave the court and don't disturb the dictation like this. बीच में आके कुछ भी बोलते हैं, सारा चीज आपका लिखा दीजिए. कोई चीज नहीं छोड़े, जो आप नहीं भी बोले हैं वो भी लिखा दीजिए.
लास्ट वाला जो था कि उसको सेम वे में ट्रीट करना होगा.
जैसे प्लेंट पूरा पढ़ते हैं ना, ऑर्डर भी पूरा ही पढ़ते हैं. और आपकी जूनियर के सामने लिखा है, ऐसा नहीं. After hearing the learned counsel appearing on behalf of the parties, it is not in dispute that by order dated 7/2/2020, the defense of the defendants was closed. It is further not in dispute that lockdown commenced from 21st
21st of March.
21st of March 2020, and lockdown due to COVID-19 situation commenced from 21st of March 2020, and prior to that, on 10/3/2021, the plaintiff had filed a petition seeking to adduce additional evidence, and the and was directed to serve a copy of the petition to the defendants. The petition was not served, and consequently on 22/3/2021, that is after commencement of lockdown, the plaintiff was again directed to serve a copy of the petition dated 10/3/2021 to the defendants. The next date was on 12/4/2021. And on 12/4/2021, the parties were directed to the plaintiff and defendant number 5 appeared, and they were directed to come ready for arguments. Defendant number 5 was admittedly not the contesting defendant. Contesting तो नहीं था?
We were contested. We had supported.
Defendant number 5 had supported defendant number 1.
Yes. So it's a contesting defendant.
Defendant number, but the appearance of other defendants is not recorded in the order dated 12/4/2021.
Yes, Lord.
The order sheet also does not reveal that the direction of the court to serve copy of the petition dated 10/3/2021 was complied by the plaintiff, inasmuch as the order sheet does not record that the petition was served. The petition seeking to adduce additional evidence was served upon the defendant number 1, who was the main contesting defendant in the case. The order sheet further revealed that the next date fixed by the order dated 12/4/2021 was 24/5/2021. It is very surprising that on 24/5/2021, there are 2 orders drawn. One is order dated 24/5/21, mentioning that due to COVID-19 situation, there is no bail, and the matter was directed to be posted on 16/7/2021 for argument. It is not in dispute that the petition seeking additional evidence was to be argued first. However, on the same date, that is on 24/5/2021, another order has been drawn indicating that the parties had taken no steps due to suspension of physical court in COVID-19 pandemic situation, and the petition dated 10/3/2021 was taken into consideration and was said to have been heard virtually, in which the plaintiff had advanced his arguments. The order reveals that though given opportunity, no rejoinder has been filed on behalf of the defendants, and none turned up to take part in the hearing on due intimation. This has been recorded, and further, the additional evidence was taken on record, marked as Exhibit 1, 2, and 3, and the defendants were given liberty to rebut the same by submission and documentary evidence. And ultimately, the matter was posted on 16/7/2021 for arguments. This court finds that the proceeding of the learned court is fallacious on account of many reasons. Firstly, there are two contradictory orders drawn on 24 5 2021, one indicating that no steps were taken and deferring the matter for argument on 16 7 2021, and other indicating that the plaintiff was heard virtually on the petition dated 10 3 2021 to admit and mark additional evidence. It is also further, the order reveals that opportunity was, though given opportunity, no rejoinder has been filed on behalf of the defendants and none turned up on behalf of the defendants. However, the order sheet does not reveal that the petition dated 10 3 2021 seeking to adduce additional evidence was served upon the defendant, served upon the contesting defendant number 1, though the order sheet dated 10 3 2021 and 22 3 2021 clearly directs the plaintiff to serve the petition dated 10 3 2021 to the defendants. But there is no endorsement, no indication in the order sheet that such petition was served. This all happened during the lockdown period, and admittedly during this period the parties were, the litigants as well as the advocates were not participating in the court proceedings physically. This is restricted participation. The participation of the litigants was restricted. This court further finds that ultimately the impugned judgment has been passed. This court is of the view that the way in which the order dated 24 5 2021 has been passed by the trial court, the same cannot be sustained in the eyes of law. This court is of the considered view that the defendant number 1, who is the appellant before this court, has been, अब कैसे बोले, defendants तो बाकी तो कोई आया नहीं, nobody else is here.
What has to issue notice then?
We'll ask them to you. They'll all appear. They are बिना notice के आ गया है क्या? बिना notice के तो नहीं आया है.
Service report completed.
Notice has been served upon them.
Yes.
They are not appearing. That is their problem. We are not bothered about it. The order dated 24 5 2021 has been passed without giving an opportunity to the, I will write defendants, नहीं तो फिर बाद में नया करूँगा, to the defendants to respond to the petition dated 10 3 2021, and consequently the order dated 24 5 2021, whereby the additional evidence of the plaintiff has been admitted, cannot be sustained in the eyes of law on this for this sole reason. However, having recorded their proceed finding, the same may not be a reason to set aside the impugned judgment and remit the case to the learned court. The learned counsel for the respondent plaintiff has rightly referred to the provisions of Order 41-25 of CPC.
This will not apply.
This court is of the view that the
How to determine any question of fact. These things will
yes,
cover.
the additional evidence has a bearing in connection with the question of fact, and therefore the matter is and therefore the learned trial court is directed to to pass fresh order on the petition dated 10/3/2021 upon service of the petition along with the enclosures thereto to the defendants, and consider the same in accordance with law and return a finding before this court within a period of 3 months from the date of appearance of the parties.
Judicial order 125 will not apply, 123A will apply. This so judgment has to be set aside for violation of principles of natural justice, and the matter has to be sent there. It's not a case where he has failed to determine any question of fact. He has determined everything, but upon taking into account something which was null and void, should not have been taken into account.
Since Lordship, what the Lordship is saying, petition dated
May have a bearing on
10/3/21.
question of fact, that's a different thing. May have a bearing on question of law
10/3/21
also.
was not rightly decided. That is required to be decided. Only a limited point is to be decided.
Yes, I will only do this.
And after that,
And thereafter, they will record a finding.
this judgment should be set aside, which has been rendered by taking into account the only set of evidences which have been taken into consideration without compliance with law.
The appeal is a continuation of suit, Lordship, and therefore this finding is recorded. If the Learned Trial Court says that these documents are not at all reliable and return the finding, the Lordship can set aside the entire judgment. That is what we are submitting. It is now thereafter upon the appellate court to decide. After that finding is returned, either it is accepted or denied.
That's
If accepted, the entire judgment will be same.
That's
If it is not accepted, then the appellate court can decide.
It's
Otherwise,
premature to say that judgment will be the same.
No. I'm not saying that. I'm taking
I
both
wasn't
the
heard
situations.
on those
Both the
evidences.
situations are
I
being
can
taken.
argue what will be the effect of those evidences.
Only on a limited point, if the thing is decided, petition dated 10/3/21, the entire matter can be decided.
The trial court's discretion to decide
They
differently
want to
on the same
reopen
set of
the entire
evidence.
case. That is what
Certainly,
they want to submit
your case was of no evidence.
without there being any objection. Even the appellate state lordship, they have not got any evidence by way of additional evidence.
Court will have to
This
pronounce a
court-
fresh
just a
judgment.
minute, just a minute. This court is of the considered view that the additional evidence which has been taken on record by the Learned Trial Court has not been taken in accordance with law. And accordingly, the fresh order is required to be passed on the point of additional evidence, and needful be done by the Learned Trial Court within a period of 3 months from today. The parties to appear before the Learned Trial Court by filing fresh wakalatnama on such and such date. Okay? The plaintiff, the defendant number 1 and the plaintiff are appearing before this court. They are directed to appear. I will give a date on that.
Yes.
इसका पूरा time frame आपको मिलेगा,
हाँ.
ठीक है? And so far as the other defendants are concerned who are not appearing before this court, the court shall issue notice to them for their appearance. The plaintiff is directed to place on record. कितने defendants हैं total?
5.
5. Place on record 5 sets of petition dated 10/3/2021 along with its enclosure, which will be available for the defendants to take it from the court itself
From the
after
trial
due
court itself.
receipt.
Yes.
On the date of appearance, the plaintiff will furnish the aforesaid documents. ठीक है? आप ले लेंगे?
That's sufficient.
यही time frame.
In addition, my opportunity to adduce evidence in rebuttal as defendant should not get curtailed by this order. That's
आपका
my
कहाँ
only
से
concern.
होगा? आपका तो ऑलरेडी लिखा ही दिए, उसमें तो था ही कि आप एविडेंस दीजिए. प्रीवियस ऑर्डर में भी था कि आप एविडेंस दीजिए. आप देखे?
उसके बाद तो हमारे
अरे भाई, आप जरा देखिए प्रीवियस ऑर्डर में क्या था. Order dated 24/5/2021. The defendant shall have liberty to rebut the same by submission and documentary evidence. डॉक्यूमेंट्री एविडेंस कैसे आप फाइल करेंगे? एविडेंस सही ना फाइल करेंगे?
जी जी
क्या करते हैं, पढ़ते नहीं, आधा आधा ऑर्डर पढ़ते। इसीलिए हम इसको इतना हाईलाइट किए। आपको तो मौका था और रहेगा, क्योंकि ऑलरेडी था, आप वहां पे बोल सकते हैं कि हमको तो पहले ही मौका दिया गया था। यू डू द नीडफुल, आपको जितना एविडेंस देना है देकर आइए, आपको जो करना है आप करके। ठीक है, एक टाइम फ्रेम रहेगा,
Yes, yes.
ऑर्डर यही रहेगा, ठीक है। आई विल जस्ट post this case on 27th August.
What time?
बहुत टाइम है,
हाँ।
हमको भी ऑर्डर करेक्शन
हाँ,
करने में टाइम लगेगा।
हो जाएगा।
ठीक है। ये चीज आप देखे नहीं, आपको ऑलरेडी था मौका।
सब
नहीं ऐसा नहीं, कभी कभी ना बिजी रहते हैं ना।
राइट।
क्योंकि ये ऑर्डर ही गलत था, माय कंसंट्रेशन वाज टू एंश्योर दैट दिस ऑर्डर गोस।
देखिए विद लिटिल एक्सपीरियंस, कभी कभी आदमी जो सोचता है ना, बस उसको उतना ही चीज दिखाई देता है।
ये आपका सेंटेंस को अब विद लिटिल एक्सपीरियंस जो सोचता है उसको उतना ही दिखता है। सो लार्जर
It
एक्सपीरियंस
is always there. The lawyers think from only from their aspect. That is the difficulty.
और ऐसा
Even the
कभी कभी
litigants.
होता है, मतलब इनफैक्ट कभी कभी, इसीलिए कभी कभी किसी चीज को जो बहुत इंपॉर्टेंट होता है उसको रिपीटेडली पढ़ना चाहिए, क्योंकि उसमें कुछ ऐसी चीजें भी होती है, जैसे उसमें लिखा हुआ है कि आपको मौका मिला, आपने फाइल नहीं किया, ठीक है। तो इसीलिए इन सब चीजों को थोड़ा न्यूट्रल एंगल से, पहले एडवोकेट को न्यूट्रल एंगल से देखना चाहिए, उसके बाद लिटिगेशन के एंगल से, देन यू विल कम एट द राइट
बोल
कंक्लूजन।
रही थी कि मेरा कुछ छूटा हुआ है।
हाँ
बोल ही रहे थे कि मेरा कुछ छूटा हुआ है।
चलिए,
Item 2, second April 21 of 2022.
Before I start the merit of this case, I have read the file and everything. Leadership, my daughter is appearing for board examination today and she
so you go,
at 1:15 the dispersal will be there and I have to go to pick her up.
so you go. You go.
Tomorrow if the matter is heard, leadership, two matters are listed today, leadership.
There are two matters.
There are two matters. One is fixed in the second half. Leadership, in that we have to file additional evidence the second half. If 1 week time will be granted, in that case, leadership, we'll file an
First
application.
of me, first of me.
First of me.
When is your daughter's board examination going to be?
Today itself it is getting.
Last.
Today is the last examination. My son, my daughter, both of them, they are appearing for board examination.
Okay.
One is 10th and other is 12th.
You should have just not come to the. When do you want to do this? You want to do it tomorrow? कल करें? देखिए इनका माइंड अभी स्टक है ना, तो she will not be able to do justice to the brief. ऐसा होता है ना, दिमाग आधा अकेली है और हम पूछेंगे सवाल नहीं देंगे जवाब, तो हम एक ठीक हो जाएंगे, ऐसा होते नहीं ना। ठीक है,
लेकिन इसको एडिशनल एविडेंस के लिए
नहीं,
इसमें नहीं, दूसरा
दूसरा दो केस
दूसरा
एकदम
लिखिए। ऐसे नंबर,
इसमें हम एक चीज कहना चाहते हैं।
आपने कुछ नोट्स वोट्स बनाए हैं?
हाँ हमने इस मैटर में क्या है, हम इस चीज कहना ये चाहते थे इसमें कि जो क्वेश्चन ऑफ लॉ देम किया गया, क्वेश्चन ऑफ लॉ इसमें देम किया गया, उसमें दो चीज इन्होंने नहीं बताया। पहला चीज तो ये कि ये डिग्री एक्सक्यूट हो गई।
अच्छा,
ये डिग्री ऑलरेडी एक्सक्यूट हो गई है। आई मीन पोजीशन ऑफ द प्रॉपर्टी, आई हैव सर्टिफाइड कॉपी ऑफ योर। ये चीज इन्होंने चाहे तो बताया
ये स्पेसिफिक परफॉर्मेंस है,
नॉलेज में नहीं था। स्पेसिफिक परफॉर्मेंस
नहीं है,
एविक्शन सूट में
पार्ट
भी
परफॉर्मेंस।
डिस्क्यूट एक तो जो इनका पार्ट परफॉर्मेंस वाला जो डिग्री है उसमें हम पार्टी नहीं, आई एम नॉट अ पार्टी, वो हमारे खिलाफ स्पेसिफिक परफॉर्मेंस का सूट नहीं है। ये भी एक बात। तीसरी
तो
बात,
ये तो बात तो फैक्ट है ना, जो आप इसमें कोई आप इसमें एडिशनल पॉइंट ऑफ लॉ
हम
इंक्लूड करना
दूसरी चीज कह रहे थे जो कि एक इम्पोर्टेंट क्वेश्चन है। सेक्शन 53A का जो एप्लीकेशन होगा, 53A का जो एप्लीकेशन होगा, 2001 के बाद रजिस्टर्ड इंस्ट्रूमेंट में ही इनको प्रोटेक्शन मिल सकता है। there is an amendment in
Yes,
this
there
section
is an
17
amendment.
itself. ये एग्जिबिट डी पर रिलाई कर रहे
Unregistered.
हैं अनरजिस्टर्ड डॉक्यूमेंट एग्जिबिट डी पे रिलाई कर रहे हैं व्हिच इज एन अनरजिस्टर्ड डॉक्यूमेंट ऑफ 2003 तो
That's
ऐसे
it.
भी इनको 43 53 ए का प्रोटेक्शन
तो इसके लिए तो आप इस क्वेश्चन ऑफ लॉ में तो आप इसमें कवर हो सकते हैं ना, तो इसके लिए कोई जरूरत नहीं है. And that decree has been executed, I will record it right now, provide her a copy.
आप प्रोवाइड करें
So we can take care of that.
एक चीज और ये क्वेश्चन ऑफ टाइटल का जो सेकंड वाला जो क्वेश्चन ऑफ both parties are claiming title. That is not the issue. I am claiming that I am a landlord, and I have purchased this property in the year 2006. And my lord, there was a landlord-tenant relationship on.
नहीं, उन्होंने अपने पार्ट परफॉर्मेंस पे तो क्लेम किया है ना टाइटल.
Part-
Whatever be the weak title, good title, whatever it is, on the basis of part performance, they are claiming that.
तो 53A वाला में हो सकता है, that I can agree.
तो first-
लेकिन 53A वाला जो भी प्रोटेक्शन इनको अवेलेबल नहीं, that उस पर मेरा
वो
argument होगा.
ठीक है, बहस करें.
और दूसरा जो कि टाइटल का जहाँ तक बात है, अनरजिस्टर्ड डॉक्यूमेंट has not been executed.
ठीक है, we will take care of that. अभी एक
हमारा-
नया जजमेंट
हमारा-
आया है इस पर.
हमारा इसमें टाइटल का इशू नहीं है, इनका हो सकता है, वो भी इस सूट में नहीं हो सकता है, इसलिए नहीं हो सकता है क्योंकि इविक्शन सूट में तो टाइटल डिसाइड होता ही नहीं. राजेंद्र तिवारी का पुराना जजमेंट है 2002.
That's
2002 का राजेंद्र तिवारी का
we'll
जजमेंट.
see that.
Yeah.
And we'll consider your argument. एक चीज लिख ले रहे हैं कि डिक्री ऑलरेडी एग्जीक्यूट हो चुका है, वो उनको भी प्रोवाइड
हाँ,
करिए और
मतलब-
मुझे भी प्रोवाइड करिए. देखिए, essay number 21 of 2022. Learned Counsel for the party not present. The Learned Counsel for the applicant has submitted that she has some personal difficulty to argue this court today and submits that the matter be placed tomorrow. The Learned Counsel for the respondent, however, submitted that it has not been brought to that the decree has already been executed in the execution proceedings. A copy of the order sheet closing the execution proceedings.
फाइनल ऑर्डर और इसके अलावा भी.
A copy of the final order has been produced by the Learned Counsel, a copy of which has been given to the Learned Counsel for the applicant.
ये तो
Then-
प्रोफेसर दे देंगे.
Undertakes to give a copy of the order to the Learned Counsel for the applicant during the course of it. Mr. Das को दे देंगे, वो तो हम भी को.
It will also affect their question of law because now they are not in position.
The Learned Counsel has submitted that consequently by virtue of eviction, the applicants are not in possession of the property. He has further submitted that the question of part performance of
2002.
the question of part performance in connection with an unregistered agreement of sale executed after 2001 does not arise, as such a document is compulsorily registrable to claim a relief under part performance. Correct?
To get protection under part.
No, to get protection under part performance. Under
So
section
far-
53, capital A of Transfer of Property Act.
So far as this suit for specific performance is concerned, that can be done, even on the basis of a unregistered law is well set. But if after 2001, if an eviction suit is filed and a person wants to claim
Protection
relief of
time.
43A, then it has to be registered after 2001.
आप हमको जजमेंट्स भी देंगे
हाँ,
कल, और इनको एडवांस में देंगे.
I know that.
एडवांस में.
I know.
Post this case tomorrow. और हमको भी एडवांस में देंगे. अभी एक जजमेंट आया है सुप्रीम कोर्ट का लेटेस्ट.
हाँ, हमने देखा.
देखा है तो बताइए.
हाँ, हम देखा, अभी हम दे देंगे.
बताइए कहाँ है, इसी इशू पर ही.
एक जजमेंट आपका भी अर्जुन का भी जजमेंट एक है जो डिजाइन वो माय लॉर्ड वाज आउटसाइड, उसका भी एक गीता देवी का जजमेंट है, उसमें भी पार्ट पर
हम एक दिन खोज रहे थे, हमको मिला ही
नहीं
नहीं.
है यार, लेकिन वो द फैक्ट्स ऑफ द केस आर इंटरली
सुप्रीम कोर्ट में कॉम्प्रोमाइज हो गया. बड़ा अफसोस हुआ कि सुप्रीम कोर्ट में जजमेंट नहीं हुआ.
लेकिन
Such a parties could-
ये उस पर्टिकुलर केस में
उनको
उनको द टाइटल
2017 volume 2 JCR
It was the
125
it was the title.
JHR.
JCR
This is JC.
it was a title suit. In that particular case, इसमें जो question of law ये था कि notice था कि नहीं अगर other side को notice था, which is also covered in the proviso. Proviso में अगर other side को अगर notice था, then उनको protection नहीं और ये aspect लेकिन ये सब aspect इसमें arise नहीं करे.
The Honorable Judge, he decided the case in my favor after a long conversation with me. आपको याद होगा कोर्ट में क्या चलता था इसमें?
नहीं, it's a beautiful landmark judgment rather.
And leadership, the other one I'm also requesting from that. Serial 3, which is fixed in the second half.
Okay, I'll adjourn it when the case is called. You ask your junior.
Yes, he'll be here.
Impugn order पढ़ के रखेंगे. ठीक है?
5 minutes.
हाँ 5 minutes.
Item 4, first appeal 107 of 2023.
बताइए, इसमें क्या करना है? अब
अब
ये मत बोलिए नहीं पढ़ना.
नहीं ठीक है, issue is very simple lordship, but since एक एक करके ध्यान थोड़ा difficulty हो जाता है.
आप एक बात बताइए, आप लोग इतने लोग हैं
Yes, yes. I do understand.
और हम अकेले हैं.
Whatever lordship is saying, I could preconceive what lordship is trying to indicate.
ऐसा है देखिए, कोई भी इस तरह के मैटर जिसमें टाइटल डिस्प्यूट्स इन्वॉल्व है, कोई जरूरी नहीं है कि हम लोग इसको एक दिन
Yes.
कम से कम शुरू तो करें.
हाँ.
शुरू करते हैं, we can post it some other day also
Yes,
for further
yes.
hearing because it will take time since you are also not much ready.
Yes.
थोड़ा तो पढ़े होंगे
हाँ,
सब.
कल
तो थोड़ा सा शुरू करिए.
बिल्कुल
एंड अभी हो सकता है पता लगे कि कुछ नहीं है.
कुछ नहीं. Lordship will kindly will find that कुछ नहीं है इसमें. Entire thing is admitted.
चलिए पढ़िए. और अगर वैसा है तो फिर it can be disposed of also if you
हाँ.
think so. बताइए.
Judgment से हुजूर फर्स्ट हम.
I'm trying to records दीजिए. Record.
The plaintiff is the applicant. Page 9 of the. Let's start from page 9.
Yes. The recording of the plain and written statement is correct.
Is correct.
Any objection with regard to? फिर इसी से
Plaintiff
पढ़
has filed suit against the
They
defendant.
should, but that has not been pointed out. I'll point it out in my.
What has been not pointed out?
The ladyship primarily at page number 10 in the submission,
हाँ.
in the last paragraph,
Hmm.
the registered sale deed of sale being 8634.
हाँ 8634.
They have filed an IA in which the additional document is to be adduced. The sale deed number says 873. And in the entire order sheet, this 8634 has been recorded.
Serial number date सब सही है ना?
सब कुछ सही है, but then sale deed number गलत है. It cannot be said to be a typographical error because it
First appeal में है ना?
Yes.
हाँ तो हम लोग देखेंगे ना document.
Yes.
है ना? First
It
appeal में
is-
तो हम लोग देखेंगे.
ये
One more thing, Lordship, I'm submitting.
ये
Since he
86
has
क्या होना चाहिए? 86.
8734 होना चाहिए.
6 की जगह 7, जो हिंदी में 6 जो लिखते हैं,
हाँ वो 7.
वो 6 7 हो गया. That is. एक बात कहेंगे उसको, जो चूंकि पॉइंट आउट करनी है. The entire case revolves upon this. There is admission on both the parts. Section 58 of the Evidence Act will come. They have not denied that Manmohan Pandey was the real owner of this land. And this is the document which says that Manmohan Pandey has purchased the land from the housing board. And this is admitted fact. Therefore, it was not exhibited since I was not the custodian of that document. And when Lordship, the judgment was passed against me, they have not adduced any evidence. Neither they have given their deposition before the trial court. And only because this document, which is an admitted thing, that I am the owner of the property, not denied by them, because subsequently we got the gift from the wife of this Manmohan Pandey. The gift deed has been exhibited. The mutation has been
the
done.
entire story starts at the stage of gift, not
At
at
the
the
stage
stage of ownership.
No. That is,
When
that
it is
an
not
admitted-
disputed, then it is irrespective.
not required
कि
to,
ये
yes.
exhibit हुआ कि नहीं हुआ,
Yes.
इसका कोई relevance
And
नहीं.
only to clear the doubt from this court lordship, we have tried to obtain the certified copy and filed an additional evidence before the December.
बढ़िया सर.
On declaring a decree by passed in the favor of the plaintiff, declaring the right title interest over the suit property. After above adjudication, further decree be passed, putting the plaintiff in khas possession over the suit property, evicting the defendant therefrom through the process of law. On adjudicating of a decree, permanent injunction be passed such and such, cost of the suit and such. The case of the plaintiff in brief is that the land measuring area of such and such square feet equivalent to 57, 5.7 decimals, title be titled more or less marked as plot number such and such Bariyatu Housing Colony Ranchi, along with the house standing thereon being numbered 2K60 having 100,000 square feet of the built-up area according to Ranchi Municipal Holding number such and such, within ward number such and such, subsequently ward number 20, present ward number such and such, such and such, such and such, is the subject matter of the instant suit, which is more fully described in the schedule below and thereafter referred to the suit property. And the suit property originally belonged to the maternal uncle, Fufa, of the plaintiff, namely Manmohan Pandey, who had purchased the same from the Bihar State Housing Board by virtue of the registered sale deed bearing number such and such, serial number such and such, date such and such. After the said purchase, Sri Manmohan Pandey has acquired absolute right, title, interest and possession of the suit property and enjoying the same as a lawful owner till his lifetime. The lawyer further submitted that the Manmohan Pandey died on 28/2/1998 at Ranchi, leaving behind his widow Chandrakala Pandey as his only legal heir and successor, who inherited and succeeded the interest of her husband over the suit property and came in possession over the same. And the plaintiff most humbly submits that since Manmohan Pandey had no issue from Chandrakala Pandey, therefore he, Manmohan Pandey, brought the defendant in his house and she, defendant, started living in the suit property with Manmohan Pandey as an concubine. Manmohan Pandey had never solemnized marriage with the defendant and she had also never given the status of the wife, which will be
What is the
evident.
name of the defendant?
Sushila.
Sushila Kumar,
Sushila Devi.
Sushila Devi had never given the status of wife, which will be evident from the service book of Manmohan Pandey, where only the name of Chandrakala Pandey finds place. The lawyer further submits that after the death of the Manmohan Pandey, his widow, namely Chandrakala Pandey, being the lawful owner of the suit property and out of great love and affection towards the plaintiff, transferred the suit property to him by virtue of the registered gift deed number such and such, body number such and such, dated 17/4/2017. It is pertinent to mention here that during the lifetime of Manmohan Pandey and Chandrakala Pandey, the plaintiff usually came to Ranchi and used to reside with them in the suit property. After the above gift, the plaintiff took electric connection in his name and also got a holding in his name from Ranchi Municipal Corporation, and Chandrakala Pandey
Just a moment. How is plaintiff related to Sushila Devi?
सुशीला देवी से कोई रिलेशन नहीं.
कोई relation.
ये चंद्रकला पांडे
तो
और
ये
मनमोहन
सुशीला
पांडे,
देवी की कहानी क्यों आई?
ये she is the concubine. She was also allowed to remain in that house of Manmohan Pandey as a concubine,
Please don't use that word.
because since lordship it is
The so-called second.
Ah.
It is an admitted position in the what I said. that
Please
she
hold
is
on. You'll
second-
have your turn.
Yes.
You please have a seat. Yes, please continue.
the plaintiff usually came to Ranchi and used to reside with them in the suit property. After above gift, the plaintiff took electric connection in the name and also got the holding in his name from Ranchi Municipal Corporation. And Chandrakala Pandey, after alienating the suit property to the plaintiff by virtue of the registered gift deed dated 21/5/17, and after her death, the plaintiff, being the lawful owner of the suit property, requested the defendant on 22/7/17 to leave the suit property and hand over the vacant position of the same to him. Initially, the defendant agreed to. It took time till January 2018. It was assured by her that she will definitely vacate the same after getting suitable accommodation. Learned lawyer further submitted that as per the assurance of the defendant, he is in the month of February 2018, that is on 4/2/18, approached her again and requested her to vacate the suit property. But this time, to his surprise, she flatly denied and started claiming the suit property to be her property, and the defendant is now claiming the suit property on that basis she is the widow of the Manmohan Pandey, and after her death and of Chandrakala Pandey, she has inherited and succeeded over the same. Learned lawyer further submitted that defendant had never been the wife of the Manmohan Pandey. She was his second wife, and as per Hindi law, she has got no interest right and interest over the properties left by Manmohan Pandey, including the suit property. Chandrakala Pandey, while she was alive and had filed a title suit in the court of Munsif Gopalganj against the defendant, and one Nandan Pandey for declaration of the deed of sale executed by the defendant with the respect of the properties of Manmohan Pandey as void ab initio. The defendant, with a connivance of Nandan
Just a
Pandey,
moment. Chandrakala Pandey, while she was alive, I filed a title suit.
against Lordship the second wife,
Which defendant?
the present defendant.
Okay.
Sushila Devi.
Shushila Devi. And that was declared null and void.
For declaration of null and void, Lordship.
Yes, then.
That was not done. The defendant, with the connivance of the Manmohan Pandey and others, have sold the properties of Manmohan Pandey, that too without having valid right to sell the same. Apart from the above title suit, for the said illegal acts of the defendant and Nandan Pandey, Chandrakala Pandey has also filed a complaint case against them. And recently, after mounting pressure upon the defendant by the plaintiff for vacating the suit property, she, defendant, has started and is trying to alienate the property by illegal means. And the plaintiff is apprehending that she may succeed in the illegal act. And if she is not restrained, he will definitely suffer irreparable loss and injury. Lordship, just I am pausing for a minute. Why, Lordship, this case has been filed? The reason has been given above. The ancestral land at Gopalganj was also being sold by Sushila Devi along with one Nandan Pandey, and one title suit has been filed. Therefore, we had an apprehension, a genuine apprehension, that this property will also be alienated. Therefore, that was the reason. After the gift, Lordship, we said that you go from this place. She took time and she did not vacate. Then after this suit was filed.
Gift was executed during the lifetime of
Chandrakala Pandey. Chandrakala Pandey has gifted.
Gifted. So, where is the question of defendant of getting any right over the property?
No right. She has no.
तो फिर आपका केस डिस्कस कर सकते हैं।
वही तो बताया ना, कोर्ट सिर्फ यही बोला ना कि वो जो हाउसिंग बोर्ड का सेल डीड नहीं लगा है 1990 का, वो नहीं लगा है, therefore it is dismissed.
चलिए।
The learned lawyer further submitted that the acts and the activities of the defendant have made the plaintiff to move his honourable court for declaration of his right, title and interest of the suit property. Hence, the necessity of the suit, and the plaintiff submits the defendant by no means of any interest over the suit property, which will be evident from the facts stated in above. But in order to grab the same by illegal means, is making and false claim over the suit property. The learned lawyer further submitted cause of action of the initiation of the instant suit arose with the jurisdiction of the Honourable Court on 17/4/17, when Chandrakala Pandey transferred the suit property to the plaintiff by virtue of registered gift deed dated such and such, when the defendant assured to vacate the suit property in the month of January 18, and on 4/2/18, when the defendant.
Just pause for a moment.
Gotcha.
ये जो gift deed है, that has not been challenged by the defendant.
No, कुछ भी नहीं, यहाँ पे नहीं आए हैं।
ठीक,
The first time they are appearing in the appeal.
ठीक।
On 4/2/18, when the defendant finally refused to vacate the suit property and started putting illegal claim over it and still continuing, and the plaintiff values the suit to the same such and such, ad valorem court fee is being paid thereon. Schedule of the property is given, Lordship. Now paragraph 3, Lordship. After service of summons, defendant appeared and filed their written statement on 18/1/19, stating then the suit is barred by principles of res judicata constructive as well as such and such and such and such. The learned lawyer further submitted the suit is read by the principles of delay and laches, limitation, estoppel, waiver and acquiescence, and the plaintiff has got no cause of action. The learned lawyer further submitted the suit suffers from multifariousness, and the frame of the suit is to be barred and such bad disjoinder and non-joined necessary parties. And lawyer further submitted the suit is fit to be dismissed for the want of jurisdiction and the cause of action such and such. Lawyer further submitted that statement made in paragraph 2 of the plaint is substantially correct to the extent that that it has describes how Manmohan Pandey came in possession of the suit property. This is admitted. Therefore, no requirement for me to proving the same.
That's right.
And the suit property was bought in the name of Manmohan Pandey. That's admitted fact.
That's right.
The other statement made in para 2 of the plaint requires no comment, being the matter of record, and the statement made in para 3 of the plaint is misconceived and disputed. It is denied that Manmohan Pandey died leaving behind his widow Chandrakala Pandey and his only legal heir and successor, and the defendant is the second wife of Manmohan Pandey. The marriage between Manmohan Pandey and the defendant was duly solemnized with all rites and ceremonies, and with the consent as per the desire of the first wife Chandrakala Pandey, and there was no issue, as there was no issue born from the first
So
wife.
she admits that she is the second wife during the lifetime of Chandrakala
Yes.
Pandey.
Who admits Lordship?
Yeah. Defendant.
They are admitting that she is the second wife.
As per their case, she is a second wife during the lifetime
Lifetime
of
the first
Chandrakala
wife,
Pandey.
therefore they have no right.
Okay, आगे. बढ़ी?
Lordship. With the consent of the as per Chandrakala Pandey, land lawyer further submitted the statement made in paragraph 4 of the plaintiff is misconceived and disputed. It is correct that Manmohan Pandey had no issue from Chandrakala Pandey and that the defendant started living in the suit property with Manmohan Pandey. The defendant was brought in the suit property by Manmohan Pandey after marriage, as stated earlier. It is incorrect and denied that the defendant lived with Manmohan Pandey as such and such. It is also incorrect and denied that the Manmohan Pandey had never solemnized marriage with the defendant and had never given the status of as wife. In this regard, it is stated that Manmohan Pandey had given the status of his wife to the defendant in all senses. Aadhaar, voter ID, LPG connection all show the defendant as to be his wife. None of the documents have been exhibited. It is pertinent to mention here in this regard that with the consent of the participation of Manmohan Pandey, one joint bank account number such and such, these things have
It
only
is
been
irrelevant.
stated.
Is there any statement in your written statement that during the lifetime of Chandrakala Pandey, she married, the defendant married Manmohan?
This is
Yes.
This is our statement, sir.
Yes, this is your
During
written
the
statement.
lifetime of Chandrakala Pandey, the defendant was married to Manmohan.
What would be the status of defendant?
Because the defendant is living in their suit property, she has a joint account with the
So what?
with
How
the
does
first.
that make a difference?
In addition, the next line.
Huh.
Further, even one joint bank account. So
No, that's okay. But you can't acquire the status of wife. You may
I
have
am,
joint account.
I am not claiming the status of the wife.
You are claiming inheritance.
I am just claiming that since I have been in possession of that property for a longer period of time, I am 72 years old. I have no issues.
72 years for the
And thereafter, since
continue,
the,
please.
Not.
The statement regarding ये joint
Further.
account का पूरा
Well, Lordship, I'm
Nothing was
skipping this.
exhibited?
Nothing has been exhibited. I'm skipping only because nothing has been exhibited, only in oral submission. Neither they have come forward as a deposition in the.
Alright.
It is denied and disputed, paragraph page 15, Lordship. 3 lines. It is denied and disputed during the lifetime of Manmohan Pandey and Chandrakala Pandey. The plaintiff usually came to Ranchi and used to reside with them in this property after the death of Manmohan Pandey. The plaintiff intentionally blackmailed Chandrakala Pandey and tried to develop independency, taking advantage of being her relative. He took advantage of her old age and has developed evil eyes over the property. The relationship claimed that the plaintiff with Chandrakala Pandey is a fiduciary relationship. The plaintiff has used his undue influence over her and has fraudulently got the said so-called gift deed manipulatedly prepared in his name. It is stated that the said gift deed is invalid and lacks attestation. It is further stated that the said purported gift deed is invalid, void, non-est in the eyes of law. It lacks attestation. Moreover, the purported witness to the said gift deed is power of the attorney holder through whom the plaintiff has got the suit filed. It is further stated that the said gift deed is forged and fabricated, and the signature of the gift deed is not of Chandrakala Pandey. It is denied and disputed that the date put under the signature and genuine or not in handwriting such and such. The genuineness of said sale deed and the signature is denied and disputed, and the plaintiff is strict proof to them. Thereof, it is disputed that there is any thumb impression or finger impression print on our said gift deed, and the plaintiff is put to the strict proof of genuineness, and the statement made in para 5 of print are misconceived and disputed. It is not disputed that Chandrakala Pandey died on 21/5/17. The rest of the statement made in para 5 of the print are denied as being false. The learned lawyer further submitted that the statement made in para 6 and 7 of the print are false and denied. It was only for the first time in the suit that such a picture was projected that the plaintiff had at any time approached the defendant for vacating the suit premises, and the statement made in paragraph 8 of the print regarding the institution of the title suit by Chandrakala Pandey against the defendant and one Nandan Pandey is a matter of record. It is stated that the allegations in the said title suit are not genuine and are rather fabricated and caused by and with the connivance of the plaintiff. Even otherwise, no evidence was given by her in the suit. The rest of the statement made in paragraph 8 of the print are wrong, misconceived and denied. When it got further submitted that the statement made in paragraph 9 of the print is denied as being false and the statement made in paragraph 10 of the print is denied. It is stated that the instant suit is not maintainable and not further submitted. The statement made in paragraph 11 of the print is denied as being false. Wrong and the plaintiff has got no cause of action and not further submitted. The statement made in paragraph 13 of the print is wrong, insufficient.
That's right.
Court fees is such and such. Thereafter, Lordship, the issues were framed.
Just a moment. The plaintiff, is he related to Chandrakala Pandey?
Yes.
Son?
फूफा लगते थे मनमोहन
फूफा
पांडे हमारे फूफा लगते थे
Relation.
yes now lordship paragraph 5 at page 70
That we have seen.
list
Let us
of
see the evidences.
lordship list of the plaintiff witnesses these are my witnesses defendant witness none.
No oral, no documentary evidence.
Yes, nothing they have produced
They did not lead any evidence.
nothing neither they have come to the court for examination in chief or cross examination neither they have exhibited in document could not have been exhibited without their examination. Nothing is-
Certainly. They chose not to examine,
Yes.
but they have just filed a written
WS.
statement.
And now,
4 witnesses were examined.
Lordship, 4 witnesses that has been discussed.
Yes.
And thereafter, Lordship, discussion and analysis at page 20. Internal page 12. Para 7. Lordship got that.
Yes.
It is an axiomatic principle of law that the court are not merely functioning to connive with the plaintiff simply because the defendant remained absent.
किस तरह का starting है? Who is this?
Sir Lawrence, such and such Lordship. Thereafter, I am reading paragraph 8. Lordship is important.
This opens the mindset of the judge.
Yes. Paragraph 8.
Yes.
This is the main issue to be decided, which will cloud with the land the respect of the matter in dispute in between the parties to the suit. Therefore, it is taken up for the first determination. From perusal of the case record, it appears that the following are the admitted facts. Chandrakala Pandey is the first wife of Manmohan Pandey. Defendant is the second wife of Manmohan Pandey. Manmohan Pandey, who had purchased the suit property. Now the court says that I have purchased the suit property, admitted fact, and my case has been dismissed since I could not bring on record the certified copy obtained by the Manmohan Pandey. The plaintiff, in support of the fact, exhibited service book of the Manmohan Pandey as Exhibit P2, where only the name of Chandrakala Pandey finds place. In the scenario where the matrimony has no legal sanction, the second wife will have no claim over the husband's ancestral property. The same, however, does not hold true in the case of self-acquired property. From where this is bolded, things are coming, Lordship, we are not aware. He would be free to leave it to anyone, including the second wife, through a will. However, in case he dies without leaving a will, known as intestate in legal parlance, his properties will be devolving upon his legal heirs according to the succession law applicable to him. Here also, Lordship, he is admitting my fact. The defendant has resisted the claim of the plaintiff on the ground that the Manmohan Pandey had given the status of his wife to the defendant in all senses, Aadhaar, voter ID, LPG connection, all show the defendant to be his wife. It is also pertinent to mention in this regard that with the consent of the participation of Manmohan Pandey, one joint account saving number such and such, such and such, such and such, maintained at Jharkhand Gramin Bank, Bariatu, Ranchi, was also opened by both Chandrakala Pandey and defendant. The defendant has not exhibited any cheat of document, neither any adduced any evidence in support of a claim. The defendant also failed to prove any document in this case in support of a fact. Accordingly, issue number 5 is decided in favor of the plaintiff. As such, from the circumstances of the cases and also from the evidence available on record, it has been established that the plaintiff's Fufa, Manmohan Pandey, till he was alive, he enjoyed the suit property as owner. He has acquired the same by virtue of the registered sale deed being number such and such, and after his death, his wife being the only legal heir of him, inherited and succeeded of the suit property, and being the owner of the same, and out of the love and affection, gifted the same to the plaintiff through a registered gift deed, Exhibit 3, and put him in possession over the same. It is further stated that after
It
receiving
has been established, he's recording a finding.
yes,
आगे बढ़िए.
क्योंकि साथ ही घर में ही रहते थे, उसी घर में रहते थे, बाकी पोर्शन में रहती थी, उनको हटाने के बोले कि आप हट जाइए.
ठीक.
She was cheated. He further stated that after receiving the suit property through gift from Bua, he also got his name mutated before the Ranchi Municipal Corporation, and accordingly, holding number has also been allotted to him, who is regularly paying taxes to the concerned department Exhibit 6 to 6B. Apart from the holding, he has also taken electric connection in his name and is paying electricity charges to the electricity board in his name Exhibit 1 and 1A. However, the plaintiff has claimed the suit property of his Kufa has acquired the same by virtue of the registered sale deed bearing number such and such dated 13/8/90 from the Bihar State Housing Board. The same sale deed has not been exhibited by the plaintiff, which is essential document and the basis of the suit for the title ownership. The contention of the documents as the electronic records cannot be proved by oral evidence. The contents of the document may be proved either by primary or secondary evidence. According to the provision of law, it provides that the contents of the documents must be proved by primary or secondary evidence, except in case of the case as provided in the Act. Hence, in order to adjudicate any document which is produced to the party has to be proved in the manner provided by the Evidence Act. Burden of proof. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of the facts which he asserts must prove that those facts exist. Plaintiff must be proved the chain of the title of the property. Chain of the title of the often described as a sequence of historical transfers. This is why my case has been dismissed. The title of the property from the current owner all the way back to the original owner. This also applies to the land without home on it. The chain of title should always reflect continuous, unbroken ownership. Since the plaintiff has not been able to produce the documents pertaining to the alleged affected sale deed by Fufa's favor by sale deed number such and such of dated 13/9/90, further the plaintiff has also not filed a complete chain of the title documents to ascertain as to how the property in question gifted by his Bua through a registered deed of gift. In fact, the plaintiff himself has not been able to prove his right title interest over the property in question. In a declaratory suit, the question of right title interest and other connected issues have to be gone into separately and meticulously. And the sale deed, which has to be, which was the basis of the plaintiff's scheme, should have been examined in its proper perspective so that the substance, the vendor of the sale deed and title of the executive stated such and such is the foundation stone of the entire such and such, that the declaration of title plaintiff is bound to proceed to all the title deeds which are necessary to trace the title. Declaration cannot be granted unless each link of the chain is complete. Lordship, we are saved, Lordship. The trial court is not saying that how the housing board has got the land, that has not been. Furthermore, in order to establish the claim of the absolute and ownership, plaintiff is required to establish complete chain of ownership, which finally culminates in his favor. It is the present case. It is still a mystery before this court who has the original owner of the suit property. It is a mystery. Who was the original owner of the suit property? The apex court has repeatedly asserting that the mutation entries neither confer any title or nor a conclusive proof of the ownership. The court have clearly spelled that the mutation entries are important only for collection of revenue, municipal taxes, and should not be hallowed in a manner to interpret impeccable legal ownership. The apex court has recently, in the judgment of such and such, reiterated that the mutation entries do not themselves confer.
क्या बोलना है आपको बताइए? What do you have to say?
In addition, the gift deed.
You have filed additional evidence.
We have filed, Lordship. The sale deed of 1990, Lordship, executed in favor of the Manmohan Pandey.
Sale deed number?
Sale deed number, Lordship.
875.
875. 8734.
873. 8734 dated 13/8/19.
It should be 873.
Lordship. 873.
देखिए कहाँ है? The registered document is a forged document.
The gift deed that we are saying is a forgery.
Forged.
Yes, and there has been no adjudication to the
The
point of
gift deed is forged. That's
Because
forget about the
he's-
forged. That's just a minute. You say that it's forged.
Yes.
You challenge a gift deed. It's a
No.
registered document.
No, we are not.
You have not challenged it. Right?
No.
Forgery is required to be proved by leading evidence and challenging the document, and you have not done all that. Correct? With respect to the interlocutory application, do you want to say that the document which has been certified copy of the deed, which is sought to be brought on record, is a forged document?
It is not a forgery.
It is not a forged document. So at least that part is,
However,
you have
there is a-
responded to it.
However, there is a dispute to the number.
That there is a dispute to the number, but otherwise
Otherwise
everything
I'm
is
not.
tallying.
Otherwise, I'm not.
Now what do you have to say?
I am saying, in my reply, I have mentioned that the conditions that have been laid down in Order 41 Rule 27 for adducing additional documents, those conditions are not part of the reason that he is claiming for the document to be adduced. That has also been taken care of in Lord Ladyship's judgment in such a case.
In which judgment?
There is Your Ladyship had
What's the
passed an order in FA number 44 of 2007,
God.
which was I'm not copying the order since it went to the Supreme Court itself also.
इसका क्या आप कोई भी जजमेंट रेफर करेंगे?
नहीं,
हमको तो याद ही नहीं रहता हम क्या जजमेंट किए
So
किस केस
I'll refer from my reply itself, Your Ladyship. That page 93. The three conditions that have been laid down, under which the documents
You forget about the additional evidence.
additional.
You forget about the additional
If the additional evidences are not adduced, therefore the chain from which he is
Chain
claiming,
has to start from where?
chain has to start from the registered deed.
No, chain has to start from the date you dispute the title. The chain has to
For
start.
me to dispute the title, they first need to establish
No,
the
no.
title.
No. You have admitted in the written
I have
statement.
admitted that Manmohan Pandey
Is
is
the owner of the property.
Owner of the property.
Admitted?
Yes, Your Lordship.
He derives ownership by virtue of the registered deed only.
Yes, Your Lordship.
Correct?
Yes.
As per the statement in the plaint and as per your written statement also,
Yes,
it is not in
Yes,
dispute.
Your Lordship.
So what was the need to adduce this evidence? It is an admitted fact, need not be proved.
It might not have been the need to adduce, but what was important.
We will reject the IFO, don't worry about it.
What was
We will not
important,
bother
what
about
was
that.
important for the learned court below to have adjudicated is that the gift deed that has not been adjudicated, because the gift deed is 25 days prior to that of the death of Chandrakala Pandey, and the gift deed does
Just
not
a
have,
moment.
Yes,
If you say that the gift deed is forged,
yes,
who has to adduce the evidence?
it has to be adjudicated.
No, who will adduce the evidence that it is forged? And whether it was required to be challenged or it was not required to be challenged.
It was required to be challenged, but then since I am in the possession of the property, I am not claiming right title over that property.
Very good. Very
I
good.
cannot, because being the second wife, I cannot claim right title over the property. But I am also saying that I have been in that property for a long period of time. I have been in possession of that property. It was admitted. Both these ladies were living together in the house since 1998, and since 1998 till 2019, there has been no challenge.
Did you plea adverse possession?
I did not plea adverse possession.
So
Your
forget
Lordship,
about
the
it, what
ladies
is
that
it?
Consenting possession lordship is not adverse possession. They are consenting.
Permissive possession.
Yes.
I was not,
Permissive possession by the owner of the property.
I was not claiming possession over the property over Chandrakala Pandey, because Chandrakala Pandey never disputed to my presence. Your
She
Lordship.
died in 2017.
2017. 25 days prior to that, a gift deed is prepared, in which there is no fingerprint or thumb impression. It is signed, which we are saying is a wrong sign, because the signs could have been also certain from the bank documents. Ladyship, that has not been done. That adjudication is important. The lady that I am defending, your ladyship, is bedridden and cannot come. She came on a wheelchair to sign the affidavit, your ladyship. I am saying on that. Now, because the lady who has been living in that property for approximately 19 years till the time this Chandrakala Pandey, because Chandrakala Pandey, if the defendant was living in the house wrongly, Manmohan Pandey died in the year 1998. Chandrakala Pandey died in the year 2017. For 19 years they lived together, have a joint account together. There's also
जॉइंट अकाउंट आपने प्रूव किया है?
हमने कुछ प्रूव नहीं किया
तो
है।
फिर क्या?
हमने कुछ प्रूव नहीं किया, बट हम ये बोल रहे हैं कि फॉर देम टू प्रूव, बिकॉज the gift deed is forged. The gift deed has to be adjudicated. The point of the fact that the gift deed, whether it is correct or not, unless the court adjudicates its correctness and veracity, there is no point of their right and title. They are claiming upon after the death of the Chandrakala Pandey. While Chandrakala Pandey all throughout her lifetime has never caused any issue. Chandrakala Pandey herself was also a nominee in one of the documents, one of the accounts that we were.
Things which are not on record please don't lie.
Everything.
नॉमिनी कहाँ है? नॉमिनी का एविडेंस कौन सा है?
Evidence नहीं है, but
Written statement without evidence is a trash of paper. What do you mean? You take a stand in the written statement. So many documents have been referred to in the written statement. You do not come for evidence. You do not even oral evidence आप नहीं देते हैं क्योंकि आपको you will be subject to cross examination.
because all this is not being done because it's not possible for the lady to travel. It is not possible for the lady to come to the court. That I am admitting here, and that is
There is a procedure for those persons who cannot come to the court how to take their evidence.
Yes.
Commissioner is appointed to take evidence.
Therefore, the court has not done it properly.
What
It
do you
should
mean
have
not?
been done properly.
You should have made a prayer to that effect. You should have made a prayer to that effect that you appoint a commissioner. For the purposes of written statement, she comes to the court.
No, for the written statement was filed, Your Lordship, because see the problem here is that, Your Lordship, for 19 years, when a lady is living in a property along with another lady who the plaintiff says has transferred the gift deed to him, has
एक
never
बात
objected.
बताइए, दो लड़के अगर 90 साल तक भी साथ रह जाएंगे, फुल ब्रदर बन जाएंगे? नहीं बनेंगे ना? फिर
But then अगर दो लड़कों को उस प्रॉपर्टी में प्रॉब्लम है तो वो during their lifetime
That will
they have to
decide.
raise an issue.
we'll decide.
The gift deed has to be adjudicated, whether it's to its veracity and correctness. That is my concern.
That's right. लिखिए first appeal number 177 of 2023 for the learned counsels appearing on behalf of the parties. The learned counsel for the appellant has also submitted that a petition seeking additional evidence has been placed on record, being IA number
1157
1157
4.
11574 of 2023, filed on 22/3/2025. However, he submits that through the additional evidence, the title deed of Manmohan Pandey has been placed on record by way of abundant precaution, as the title of the suit property was with Manmohan Pandey is an admitted fact on record, and such finding has also been recorded by the learned trial court. कुछ explanation दिए? Why did you bring it on record?
Paragraph 13 onwards.
The learned counsel has also submitted that
Also.
the title deed of Manmohan Pandey was not produced before the learned trial court in view of the fact that the defendant who had filed a written statement never objected to the contention of the plaintiff that Manmohan Pandey is not the real owner of the suit property.
Paragraph 15 and 16 also.
The learned counsel has also submitted that it has also been stated in para 15 of the interlocutory application that since plaintiff was not in custody of the sale date dated 13/8/1990, as such the sale was not exhibited before the learned trial court. And on account of the admitted position that the property originally belonged to Manmohan Pandey, he did not take any step earlier to take the certified copy. He has further submitted that the learned trial court has dismissed the suit only on the ground that the title deed of Manmohan Pandey was not exhibited. The finding of the learned trial court is contrary to his own finding, wherein he has recorded that the property admittedly belonged to Manmohan Pandey. The learned counsel has submitted that admitted facts need not be proved, and for this he refers to evidence first section
58 of the evidence.
section 58 of the Evidence Act. The learned counsel has submitted that though the defendants had filed a written statement and had referred to numerous documents, besides admitting that the suit property belonged to Manmohan Pandey, but the defendant neither adduced any oral evidence nor adduced any documentary evidence before the court, and the suit proceeded only on the evidence produced on behalf of the plaintiffs. The defendants did not even appear to cross-examine the witness produced on behalf of the plaintiff. The learned counsel has also submitted that a plea was taken by the defendant that the gift deed on the basis of which the plaintiff was claiming to have registered gift deed on the basis of which the plaintiff was claiming right, title, interest and possession. The same was a forged and fabricated document. However, the said gift deed was never challenged by the defendant, nor any evidence was placed on record. He has also submitted that the person who alleges fraud and forgery, the onus is upon that person to lead evidence and prove forgery and fabrication of document. And otherwise also, such a plea could not have been entertained as the gift deed was not under challenge by the defendant, as any prayer to set aside this registered gift deed was not made by way of any counterclaim or by filing a separate suit.
And the registered document has a presumption of correctness.
The learned counsel has also submitted that the registered document has a presumption with regard to due execution
Due execution of the said deed.
of the same. The learned counsel, appearing on behalf of the sole respondent, who was the defendant in the suit, has opposed the prayer and has submitted that the the specific case of the defendant in the written statement was that the defendant had solemnized marriage with Manmohan Pandey with the consent of Chandrakala Pandey, the first wife. As Chandrakala Pandey and Manmohan Pandey did not have any issue. And during the lifetime of Manmohan Pandey and Chandrakala Pandey, the sole defendant started living in the suit premises, and Manmohan Pandey died in 1998, and thereafter the sole defendant continued to live with Chandrakala Pandey, who died in the year 2017. The learned counsel has submitted that the gift deed was executed in the year 2015.
17.
The gift deed is executed on 17th of April 2017,
Or
while the Chandrakala Pandey died on 21st of May 2017.
the gift, Chandrakala Pandey expired on
21st of May 2017.
21st of May 2017, and the gift deed was executed in favor of the plaintiff on
17th of April 2017.
17th of April 2017. He submits that the gift deed was executed immediately prior to the death of Chandrakala Pandey, and the defendants in their written statement had specifically asserted that the gift deed was forged and fabricated. But the learned trial court did not frame any issue to that effect. Issue है?
Issue है, but then we not said it. No. The issue was whether the plaintiff has any right, valid right.
But the learned trial court did not frame any issue with regard to the legality and validity of the gift deed. The learned trial court ought to have decided this issue, and it was for the plaintiff to prove the genuineness of the gift deed on the basis of which the plaintiff was claiming title over. यही आपका? With respect to the additional evidence, the learned counsel has submitted that there is no explanation on behalf of the plaintiff for not producing the title deed of Manmohan Pandey during the trial, and therefore the additional evidence is not fit to be admitted. He has submitted that the provision of Order 41 Rule 27 to enable the appellate court to take additional evidence is not duly satisfied in the present case, and the appellate court can be permitted to take additional evidence only if the conditions laid down in the rule exist. The learned counsel has submitted that the learned trial court has rightly passed the judgment against the plaintiff on account of non-production of the title deed of Manmohan Pandey.
The number of sale deed.
The learned counsel has also submitted that the deed which has been, the title deed of Manmohan Singh, which has been sought to be Manmohan Pandey, which is sought to be executed, is deed number 8732 of 1990. 8734 of 1990, and in the plaint the deed number was mentioned as 8634 with serial number 9279 dated 13/8/1990. Serial number is tally. The learned counsel, however, the respondent has filed a reply to the petition seeking additional evidence. However, the However, it is not the case of the respondent that the additional evidence which has been sought to be adduced before this court is either forged or fabricated. The learned counsel appearing on behalf of the respondent, on the other hand, on behalf of the appellant, has submitted that the perusal of the additional evidence revealed that the serial number which was mentioned in the plaint is correct, and the fact that the registered document indicate that the property and the other details with respect to the property is with, in the name of Manmohan Pandey is evident from the additional evidence itself. The learned counsel has submitted that, has reiterated that on account of the admitted fact that the property belonged to Manmohan Pandey, even in absence of the additional evidence, there is no impediment on the part of the court to decide the case. He has submitted, that's all?
Yes.
After hearing the learned counsels appearing on behalf of the parties, you see impugned orders से case of respective parties ले सकते हैं?
वो दोनों से
ठीक है? ये ले लेंगे इसमें से, ठीक है? You just type it, I'll cut short that. Scan में मिल जाएगा आपको.
I've also prepared
ये uploaded.
written notes available for your convenience.
अब तो आपका लिखा दिए ना, अब क्या लिख?
मतलब आपको लिखवा देना चाहिए.
Admittedly, the defendant, after filing the written statement, did not cross-examine any of the witnesses produced on behalf of the plaintiff, including the plaintiff himself who was examined as PW3, nor led any evidence, either oral or documentary. The plaint and the written statement reveal that the suit property admittedly stood in the name of Manmohan Pandey. Further, admittedly, Chandrakala Pandey was his wife, and it was the specific case of the defendant in the written statement that during the lifetime of Chandrakala Pandey, Manmohan Pandey married with the defendant, and Chandrakala Pandey as well as Manmohan Pandey started living with Chandrakala Pandey as well as the defendant started living with Manmohan Pandey. And that the defendant has been living in the property since then. It is further an admitted fact that Manmohan Pandey, ये admitted fact में नहीं आएगा, it is a case of the defendant. It is पैरा करके लिखिएगा. It is an admitted fact that Manmohan Pandey died in the year 1998 and Chandrakala Pandey died in the month of May 2017. ऊपर डेट दिया है, वही डाल देंगे. The plaintiff had specifically claimed the suit property by virtue of a gift deed. By virtue of a registered gift deed dated 17/4/2017, executed by Chandrakala Pandey after death of Manmohan Pandey in favor of the plaintiff. This was exhibited as Exhibit 3. It is further not in dispute that the plaintiff has been living in the suit property.
Plaintiff is not living in the
You said in the portion of the suit property she was living.
The defendant
Is living in a portion of the suit property.
the defendant is living on the plaintiff. The litigation
Defendant is living in the entire suit property.
he is living in the property. That's what.
अच्छा कोई बात नहीं इस लास्ट सेंटेंस हटा दीजिए
No, because your ladyship
कोई
dictated
बात
plaintiff.
अब सॉरी
आपने plaintiff बोल दिया तो plaintiff.
अच्छा कोई बात नहीं ये हटा ही दीजिए लास्ट सेंटेंस कोई काम ही नहीं है इसका This court further finds that the defendant in their written statement had alleged that the registered deed of gift was a forged and fabricated document and therefore the defendant had disputed the title of the plaintiff on that basis. However, the registered deed of gift was not challenged by the defendant in any proceeding, and in the present proceeding also, no counterclaim. Counterclaim पड़ता क्या पड़ता?
काउंटर क्लेम ही पड़ता है बट इसमें वो भी रेलेवेंट नहीं होता
No, neither any counterclaim nor any cross suit has been filed.
नो एनी फ्रेश सूट
Nor any suit challenging the registered gift deed has
yes
been filed.
that will suffice
Yes. The learned court framed the following issues for consideration, and since the gift deed was not under since the registered gift deed was never under challenge by cross suit or by any counterclaim, the learned court rightly did not frame any issue with regard to the legality and validity of the gift deed, and has framed the aforesaid issues for consideration. This court also finds that the witnesses produced on behalf of the plaintiffs, 4 witnesses, ये पैरा फाइल में सारे details of witnesses have been considered by the learned trial court, and the learned trial court in paragraph 7, which is the opening paragraph dealing with discussion and analysis, has observed that it is axiomatic inverted comma में डाल देंगे principle of law that courts are not merely functioning to connive with the plaintiff simply because the defendant remained absent. This court is of the considered view that there is no question of any connivance of the court. The court always remains neutral. The court is required to adjudicate the case on the basis of materials brought on record by the respective parties. Certainly, when the defendant, in the present case, the proceeding was not an ex parte proceeding. The defendant had filed the written statement and had the opportunity to lead evidence and also to cross-examine the witnesses. But the defendant consciously did not choose to take any steps, nor any explanation is forthcoming on the part of the defendant as to why the defendant did not take any steps for the purposes of leading evidence or to cross-examine the witnesses led by the plaintiff. Certainly, in a case where the proceeding is ex parte and the defendant is not otherwise participating in the proceedings after filing of the written statement, the court is required to be conscious while adjudicating the case, but by no stretch of imagination it could have been observed by the learned court that courts are not merely functioning to connive with the plaintiff simply because the defendant remained absent. This court finds that so far as issue number, the learned trial court has recorded the admitted facts in paragraph 8, and one of such facts was that Manmohan Pandey was the person who had purchased the property, paragraph 8 of the judgment. This court finds that the admitted facts has been rightly remunerated by the learned trial court in paragraph 8. The learned trial court further considered the materials on record and also recorded that the defendants did not exhibit any document or any evidence in support of her written statement, and documents were exhibited on behalf of the plaintiff. And and issue number 5 was decided in favor of the plaintiff. This court further finds that the learned trial court, by considering the claim of the plaintiff with regard to chain of title, has observed that the title deed of Manmohan Pandey was not exhibited, and thereby ignored the fact that the title of Manmohan Pandey with respect to the sued property is an undisputed fact on record and already taken note of by the learned trial court in paragraph 8 by enumerating the admitted facts on record. This court further finds that it was the specific case of the defendant in the written statement that she married Manmohan Pandey during the lifetime of Chandrakala Pandey, and therefore, by virtue of such a status, by no stretch of imagination, the defendant acquired the status of wife of Manmohan Pandey. However, the fact remains that the defendant did not appear before the court to depose on her status with respect to Manmohan Pandey, so that she could have been subjected to cross-examination on various aspects of her relationship with Manmohan Pandey. With respect to the chain of title, the learned trial court, while considering the issue number 6, has observed that since the plaintiff has not been able to produce document pertaining to alleged sale effected by his fufa in affected in his fufa's favor, that is in favor of Manmohan Pandey, that is sale deed bearing number 8634 dated 13/8/1990, the chain of title was not complete. This court is of the considered view that the law is well settled that admitted facts need not be proved. The fact pleaded by the plaintiff that the property belonged to Manmohan Pandey was neither disputed in the written statement nor at any stage, and it is not in dispute even at the first appellate stage during the hearing. This court is of the view that in such circumstances, the non-production of the sale deed in the name of Manmohan Pandey dated 13/8/1990 was not fatal to the suit and the claim of the plaintiff. Rather, the learned trial court has committed gross illegality by refusing to decree the suit in favor of the plaintiff on account of non-production of the sale deed dated 13/8/1990. The sale deed has been produced by way of additional evidence, but on account of the admitted fact on record that the property belonged to Manmohan Pandey, this court does not find it necessary to allow the additional evidence. Though the sale deed, the deed in name of Manmohan Pandey has not been otherwise disputed by the respondent, who has filed reply to the interlocutory application, and his only ground is that the provision of Order 47
Order 41 Rule 27.
Order 41 Rule 27 are not satisfied. Since this court has recorded that the deed standing in the name of Manmohan Pandey, being an admitted fact on record,
Has no bearing.
has the additional evidence brought on record has no bearing on it. Accordingly, the finding of the learned trial court with regard, so far as the argument of the respondent with regard to the legality and validity of the gift deed is concerned, it was a specific case that the gift deed is forged and fabricated. It was for them to adduce evidence and take steps, and also to challenge the gift deed, which is a registered document, and in absence of such challenge to the gift deed by cross suit or by cross objection.
Cross objection.
Cross objection. पढ़ता है, क्या पढ़ता है?
Cross objection.
Cross objection. Or by cross objection. Cross objection नहीं पढ़ता है.
Written statement.
Counterclaim.
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 6A.
Counterclaim. The learned trial court has rightly not framed any issue on them and rightly not returned any finding in the same. The other issues this court finds that the plaintiff had a valid cause of action as pleaded and proved, and therefore the
And also,
plaintiff was
Lordship, the issue number
entitled to
5
relief.
has been decided in favor of the plaintiff, which says, Lordship, whether the Chandrakala Pandey entitled to alienate the suit property.
Yes.
That is in my favor.
That is in that I have already read.
Yes.
Consequently, the impugned पूरा judgment and decree सभी set aside हो
हाँ.
क्योंकि कुछ तो findings आपके favor में
The part of the judgment. with
हाँ
regard
the
to
impugned judgment so far as it relates to issue number 1, issue number 7 and 8 and issue number 6 2, 3, 4 तो आपके favor में decide हो
Lordship.
issue number 6, 1, 7 and 8 right
Yes.
Are set aside and the findings with regard to issue number 5, 2, 3 and 4
2, 3, 4 and 5.
2, 3, 4 and 5 ठीक है
Lordship.
is upheld. Consequently, the suit stands decreed. The appeal is allowed.